My lord, I beg to mention a case, my lord, for suspension matter, my lord. It was left out on 18/5, my lord, and I'm going to retire, my lord, August. So may I pray, my lord, to be listed
You're
on
going to retire when?
August, my lord.
Ah.
So may I pray, my lord, to listed on Monday, Tuesday, any day, my lord.
No, you have it listed on 9th of June.
Lordship, I beg to mention item number 37 and 38. We have already taken consent from the petitioner.
Hmm.
So it may be,
Lordship, because of, I've been told that Mr. Sanjay Mehdi, he has some bereavement today. So may I play that the matter may be taken on next week, any date, Your Lordship. The matter is a relating suspension. All the pleadings are complete. Just that on the Deepak Mali.
8th of June.
8th of June.
Mr. D. Bora, learned
Lordship.
counsel for the petitioner. Yes,
Lordship, SK Mehdi will not be available on.
you make alternative arrangements. Mr. D. Bora, learned counsel for the petitioner. The petitioner is present in both these cases. A prayer for adjournment has been made on behalf of respondent numbers 1 to 4. On the ground that the learned counsel, Mr. SK Mehdi, is unavailable. Full stop. Although Mr. Bora has expressed urgency in the matter, considering the ground on which the prayer for adjournment is made, the same stands allowed. On the request of Mr. D. Bora, let these matters be listed again on 8th of June as fixed items. It is made clear that no prayer for adjournment will be entertained in these matters on the next date.
Highly
Obliged.
My lord, I beg to mention, my lord, item number 3, my lord.
Yes,
My lord, the matter may come up in the next week, my lord.
on the prayer of learned counsel for the petitioner, Mr. A.M. Borguya, this matter stands adjourned for a week. Yes.
May I please, your lordship? My lord, I beg to mention for listing of a motion item, my lord, on Friday, my lord.
What is the matter?
My lord, that's the Gram Pradhan selection and appointment.
What is the urgency in that?
My lord, it was filed long back on 9/5, my lord, appointment.
Monday. Take the date of Monday.
Obliged, my lord,
5th
obliged.
of June.
May
My-
please, your lordship. Lordship, I beg to mention item number 47, lordship.
Yes,
Matter may be passed over for the day, lord.
47.
47, lordship.
On the prayer of Mr. A. Sharma, learned counsel for the petitioner, this matter stands adjourned for a week. Yes.
My lordship, I beg to mention for listing ignition matter was last posting from 20.
3rd week of June.
May please, your lordship, prayer for listing, WPC 500 plus.
3rd week of June.
Third week of.
May it please, your lordship. Lordship, I beg to mention item number
You
59.
write 3rd week of June in the mention menu. Yes.
Lordship, item number 59, stay vacating matter. Lordship, today I filed my reply. I may be allowed to take the matter. Bring the reply into the record.
Item number?
59, your lordship.
Yes.
Order stay vacating. Much obliged, your lordship.
May I please, your lordship? Lordship, I beg to mention item number 25 and 26.
Yes. What do you want?
Next week,
Why next week? After vacation. That service is not available, not today, on that day, that is not available. There are other cases which are lined up. Why you want adjournment today?
my senior is not present today.
All right, then we'll adjourn it on the prayer of learned counsel for the petitioner made with the
Obliged.
consent of the other side. These matters stand adjourned for 2 weeks. List accordingly. Item 25 and 26. Yes,
My lord, may it please, the lordship. I filed IA for my lord suspension of the appointment order, my lord. The main case is pending, my lord, and tomorrow, my lord, the appointed candidate going to join, my lord. What is, my lord?
no, what, rejected? What is the urgency here?
Agency, my lord, the appointed candidate, my lord, going to join on, my lord, tomorrow, my lord.
So, when did you file the writ petition?
Repetition, my lord, in the year 2019, my lord.
And today you want a IA to suspend this joining?
No, my lord. Yes, my lord, but
No
because of,
prayer
my
is
lord,
rejected, sorry. It will come on ordinary course, we'll see.
I beg to mention an IM, my lord, that will be taken in Monday, my lord.
What is the IA about?
IM for restoration, my lord.
Restoration, Wednesday, next
Yes.
Wednesday.
May I please, lordship?
Yes,
Prayer for adjournment of item number 24
item number
with the
24.
consent of opposite party.
Yes, why you want adjournment?
My engaged senior counsel is suddenly fallen ill.
You are for the petitioner?
Yeah.
What is your name?
Parinita Sharma, P. Sharma.
On the prayer of Ms. P. Sharma, learned counsel appearing for the petitioner. Admission hearing of these matters stands adjourned for 2 weeks. List accordingly. Yes. Mr. H.I. Chaudhary, learned counsel for the petitioner, submits that he has instructions from his client to withdraw this petition. The prayer is not opposed by Ms. Mushari.
Respondent note 3 and 4.
Ms. Mushari, learned counsel appearing for respondent numbers 3 and 4. In view of the above, this petition stands disposed of on withdrawal. Is there any interim order? Ms. G. Bora, learned counsel for the petitioner, submits that PS instructions. Mr. S. Datta, learned SC PNRD Department.
SC, sorry, Revenue Department.
Revenue Department, Assam, and Ms. M. D. Bora, learned Government Advocate, Assam, are present. In view of the above, this petition stands disposed of on withdrawal. There is no interim order here.
No interim order.
For motion, I can.
Okay.
Yes.
My lord, petitioner was appointed in the year 1990, Lordship,
Hmm.
and thereafter in the Inland Water Transport Division, Assam, Lordship. And thereafter,
MSCP benefit has been denied.
no, that was also not given, no promotion was considered, Lordship. I have made a representation to the authority. That is, Lordship, kindly have a look at page 16, annexure 6, Lordship. That was also not considered. There is a vacant post of foreman.
আপনি একটু BRC তে পেয়ে উইথড্র করেছেন BC পেয়ে উইথড্র করেছেন উইথড্র করেছেন
BC. That will be one ABC anytime at 8
So which is the service rule here?
Lots of it is.
You don't know. Then I'll dismiss it.
My lord, before that lordship, the petitioner had filed one IA for amendment of his prayer, my lord. The prayer BC has already been deleted, my lord.
Hmm.
And for only for prayer number A lordship, I have received instruction, my lord.
What is prayer number A?
A written the nature of mandaments shall not be issued directing the responding authorities to provide sanction of another post of electrician. And I
Not
have
this
received
is
instruction.
foreman lordship.
This is prayer A. He
Lordship,
may withdraw this petition, file a fresh lordship,
Lordship,
because
kindly-
he have
kindly see
amended this prayer.
Prayer my
Prayer is a page.
page lordship. Six lordship. 5 and 6.
You are in WPC number
Lordship 7312.
7312. There is no prayer number 5 and 6.
Page number lordship. Page
Page
number.
is there, but there is no prayer A and prayer B.
Only prayer lordship to promote the petitioner to the post of foreman lordship or junior.
No
That
prayer,
was
lordship.
amended. That was
No copy has been served to me then.
I'm
Only
maybe
the
allowed
prayer
to
A
serve-
read in the nature
That was
mandaments shall not
already
be issued.
amended lordship.
All right. Then you obtain in the, you don't even know which is. the rule.
Lordship, I will satisfy your lordship next week.
So as per my instruction, lordship, may kindly have a look my instruction.
Hmm.
The earlier, as per Assam Inland Water Transport Draft Service Rule, promotion to the post of junior engineer is made from the sub-engineer cadre 1, but there is no rule in the Assam Inland Water Transport Draft Service Rule in promotion to the post of foreman, junior engineer from the post of electrical supervisor. He's an electrical supervisor. There is no rule.
There is no promotional avenue for.
Avenue.
But then you have to do something about it.
Yes, and then the other benefit, if he is entitled,
Hmm.
then we'll consider.
You will be satisfied with
Lordship,
MSCP.
lordship.
If he is entitled as per law, lordship may observe that much.
All right, take down. Mr. L. Majumdar, learned counsel appearing for the petitioner. Also heard Ms. M.D. Bora, learned standing counsel, Transport Department, Assam, appearing for the official respondents. The case of the petitioner is that he was appointed as an electrical supervisor in the office of respondent number 3 by order dated 9/11/1990, and since then he is serving in the same post. First up, according to the petitioner, he is drawing the scale of he's drawing this pay scale of foreman oblique junior engineer in the department, and is entitled and therefore is entitled to be promoted to the post of foreman. Post of alternatively, the petitioner had prayed for extending him the benefit of MSCP in lieu of promotion. First of, when his prayer was not considered, the petitioner had submitted representation dated, what is the date of the? Dated
Lordship,
11/5/2022, addressed to the Director, Inland Water Transport Department, Assam, ventilating his grievance in the matter. First of, when the representation failed to evoke any response, the petitioner has approached this court by filing the present writ petition. First up, Ms. Bora, on the other hand, has obtained instruction and submits that that promotion to the post of junior engineer is made from the feeder cadre of sub-engineer grade 1, and as per the Assam Inland Water Transport Draft Service Rule, there is no provision for promoting an electrical supervisor to the post of junior engineer. On such ground, Ms. Bora submits that the prayer of the petitioner cannot be considered unless proper provision is made in the rules for promoting electrical supervisors. On the plea of refusal to extend the benefit of MACCS to the petitioner, modified Assam Assured Career Progression Scheme, MACPS, close to the petitioner. She submits that his case will be considered if the petitioner is found to be eligible under the rules. Mr. Majumdar submits that his client will be satisfied if this writ petition is disposed of with a direction to the respondents to consider his grievance.
Number 2, my lord, director.
Huh?
Respondent number 2.
Yeah. In view of the above and with the consent of, you're right, then you're right. Law is firmly settled that right to be considered for promotion is a fundamental right of the employees. First of, it is also the settled law that an employee is entitled to at least one promotion during his entire service career. First of, if for any reason such as non-availability of proper provision in the rules, such promotion cannot be denied, then the employee must be extended the benefit of career progression scheme by giving him the financial benefits. Therefore, this court is in the opinion that the prayer made by the petitioner deserves consideration by the appropriate authorities. In view of the above, with the consent of learned counsel for both the sides, this writ petition is being disposed of at the stage of motion hearing with a direction upon the respondent number 2 to consider the representation submitted by the petitioner in the light of the observations made here and above and pass appropriate orders herein. The exercise be carried out and completed within a period of 3 months from the date of receipt of a certified copy of this order. The respondents may also consider incorporating appropriate provision in the draft service rule so as to provide avenues of promotion to the electrical supervisors if so advised.
My lord.
The writ petition stands disposed of accordingly. What are the IAs?
Lordship, IA was for amendment of the prayer.
Already?
It was disposed.
All right.
Lordship, I have another small prayer.
Hmm.
The item number 1 of daily code list of 29/5/2023, Lordship.
Hmm.
There is some small typographic error. I did not obtain any certificate copy. Lordship, can it be rectified without filing? IA or it is filing?
You think
Lord,
it
I have not obtained any certificate.
is this how high court orders are modified?
Lordship, small types.
You,
That's
you
why I
have,
am
you have
praying.
spent sufficient time in the practice, Mr. Majumdar.
That
You
is
should know what kind of a request a lawyer is entitled to make.
Yeah.
Otherwise, what
Other-
we'll say only is rejected. Yes.
My lord may keep my instruction as a part of the record.
The written instruction obtained by Ms. Bora be retained in the record.
I am deeply obliged, my lord.
Yes, who is this? All right, you take down. None appears for the petitioner on call.
Item 4. My lord, in this petition, my lord, the question is reduction of rank from SI to ASI, my lord.
Let the notice go at this stage, Lordship.
Heard Mr. Ayya Talukdar and counsel for the petitioner. The petitioner is aggrieved by reduction by
Order of the
imposition
appellate.
penalty whereby his rank has been reduced from SI to
ASI.
Yes,
ASI.
first of- I have perused the grounds taken in the writ petition. First of Mr. H. Sharma, learned additional senior government advocate Assam,
All the respondents.
appearing for the respondents have prayed for 4 weeks time to obtain instruction in the matter. Stop. Issue notice returnable in 4 weeks. Since Mr. Sharma has appeared and accepted notice for all the respondents, no formal notice is required concerning this case. Extra copies of the writ petition requisited in numbers. Yes. Yes, yes.
Yes, Lordship, we have received the instructions.
Hmm.
Uh, He did not appear in front of the interview committee, Lordship.
Hmm. Your client did not appear in the
Lordship,
interview board.
I had appeared in a written physical test, I have voice before the authority. The respondent authority had issued several certificates in favor of me.
You did not appear. What can be done?
I had appeared in physical test also,
No, you have
certificate.
to appear in the interview also. You will appear in the half and not the other half, and then you want appointment. How is it possible? Mr.
Lordship,
Burman,
Lordship, I will confirm it.
what you will confirm?
The respond, no,
Where have you stated that you have appeared before the interview board? Where is the statement?
Lordship,
Where is the statement in the writ petition? Hmm?
Lordship,
Where have you stated that you have appeared before the interview board?
para number 8, 9, 10,
Which line? Please read it.
para number 8,
Hmm.
page number 10.
Hmm.
The petitioner submits that after completion of above written examination and other tests, the state level police recruitment board Assam had invited the petitioner for oral fiber voice examination held on Iman. At police reserve Bongaigaon for the post of constable so in Assam police. Accordingly, he had appeared before the concerned authority for said oral fiber voice examination at roll number so and so.
He says he has appeared.
Lordship.
Then you have
So
to file an
better,
affidavit.
better to bring the record, Lordship.
Yes.
That will be better.
Heard Mr. S. Burman, learned counsel for the petitioner, also heard Mr. H. Sharma, learned additional senior government advocate Assam, who has obtained instruction dated 35/2023. and place a written instruction dated 35/2023 and place the same before this court. A perusal of the written instruction goes to show that the petitioner did not appear before the interview panel and therefore his name was not included in the final merit list. The above stand of the department contradicts the averments made in para 8 of the writ petition, wherein the petitioner has categorically stated that he had appeared before the interview. In view of the above, it has become necessary for this court to peruse the departmental records pertaining to the selection process. Mr. Sharma to therefore produce the record on the next day. This case again on 12th of June 2020, 12th June. For motion as a fixed item. A copy of the written instruction dated 35/2022 be written in the record. Yes. Would like that.
Well, I have received the instructions, my lord, and what I have been informed that the facilities are there. There is a composite hospital in Bangalore, and the provision for treatment of the HIV is very much available. And
Lordship,
my lord,
that even in the as per the policy decision, Lordship, as per the transfer policy, page 36 of my petition, Lordship, a Mohila battalion is entitled for in a place for the period of the 8 years. Page 36, clause 12, Lordship, that transfer of an Mohila personnel. And I joined in this in Guwahati on only on the 2018. That
When did you join at Guwahati?
on 2018, Lordship.
That is not the date, that is a year. What is the date?
Yes, Lordship, that in the last part of the December 2018, Lordship, that exact that. And in the clause 12,
So you are saying the treatment that available in Guwahati is not available in Bangalore?
no,
People
Lordship,
go from Guwahati to Bangalore for treatment?
no, Lordship, that one difficulty in the battalion, there is a company. In company is located in the rural area or in the other place also. That is also.
So we'll ask them to ensure that the petitioner receives adequate
Lordship,
treatment.
may I just pray only for deferment of for the period of 1 year.
no,
if-
no.
Even on the, I filed a
So
reply.
what will happen in 1 year?
Lordship, that so that I can arrange the things, Lordship. My parent,
No. These are.
I am a widow, Lordship. I have the.
If we start entertaining this, then we will have a cell here to carry out transfer orders.
Yes.
We are not getting into it,
Lordship, that
Mr. Vijay.
clause 12, clause
All
12,
right, all
Lordship,
right. You
paragraph B.
spend 5 years.
No, Lordship, that I am entitled for 8 years, Lordship.
No, my lord, 4 years. The wrong-
Where is your entitlement?
Yes, Lordship, that
Not
clause
that
12,
is 4 years, my lord, that
clause
is over.
12, clause 12, group C post, Lordship,
Page number?
page number 36. That the group C 8 years of the service and subsequent posting 8 years subsequent field as on 30 March of every year under considerations.
Page number 36, clause number?
Clause 12, transfer of the Mohila personnel. Clause A, group C post, Lordship. I belongs to the group C post. And even in the group B also, there is some procedure, how they can transfer me, Lordship. That procedure has
So
also.
this
not
is
been-
first place.
First place, and the subsequent is Lordship for 8 years.
So that is in P station, 8 years.
My
Yes,
lord,
Lordship.
she-
Guwahati is a speed station, Lordship.
Bangalore is also P station.
Lordship, that, and even in the
It doesn't say in the same place.
Lordship, that
It only
No.
says P station.
is, even in the clause B also not followed, Lordship. Clause
my lord,
B.
she is constable GD. Mahila personnel and band personnel, they are separate classes, my lord. She is not Mahila personnel. My lord, will see page 35. That is transfer of band personnel, and then it is transfer of Mahila personnel.
Yes, Lordship.
She is not Mahila personnel, she is
I'm-
constable GD.
No, I
For
am,
constable GD, my lord, page 26.
I'm the Karmasari
Is the
Lordship, Safai
normal
Karmasari.
4 years is the pay, my lord will take page 26.
I'm the Safai Karmasari.
Normal tenure in field station is of 4 years, and for hard field area and field stations, it is 3 years. And my lord, I have already received the instructions, and she has already completed more than 4 years in the static normal tenure field
So
station.
page 26, which clause you are referring
My
to?
lord, 8, my lord. Roman 8, normal tenure in field station is of 4 years, and for hard field areas, it is 3 years.
So Guwahati is a police station.
What is the police station, and Bangalore is also, my lord, same.
Lordship, the I am governed as per the clause 12, Lordship.
She gets 1 month time to join. from
Lordship,
today.
just even clause 12B, Lordship, for a moment, clause 12B,
Yes.
page 36, clause 12B.
Mr. Bejbura, you have to understand, we cannot sit in appeal over the decision of the employer to transfer employees. Even if they make a wrong transfer, even then the read code cannot.
Lordship.
The read code will only interfere if it is a violation of right. The transfer ends up in violation of right. Otherwise, this country will come to a standstill.
Lordship.
And nobody wants to go to certain locations. If the read code starts saying, send him there, send him back, send her there, it will create a chaos. That is the reason we'll dismiss your read petition, but we'll give you 1 month's time to join. You can argue. After we finish.
No, Lordship, that only 6 months time may be given.
No, my lord, already
This-
releasing order has
This
come.
practice should not be entertained.
Clause
Already
12B,
order
Lordship, he has also not.
All right, heard Mr. Bejbura, H. Bejbura, learned counsel appearing for the writ petitioner. Also heard Mr. H. Gupta, learned CGC appearing for the respondents. Assailing the transfer order dated
Page 17, Lordship,
page
page 17,
70.
17.
Transfer order dated 2/3/2023, by means of which the writ petitioner was transferred from Guwahati and posted at CTKS bracket EXE bracket. No, that is the RAN. Where is the posting?
That 240 Mohila Battalion is in the Bangalore, Lordship.
Posted at the 240 bracket M bracket close battalion at Bangalore. The instant writ petition has been filed. Full stop. The case of the petitioner is that she is serving under the CRPF as a constable and working as a Safai Karmachari. First of all. The petitioner is presently receiving medical treatment for human immunodeficiency virus bracket HIV bracket close at the medical center at Guwahati. First of all. The ground on which the instant writ petition has been filed is to stall, STAL, stall her transfer on the ground that there is no proper medical care facility at the battalion camp at Bangalore. Instead, taking note of the grievance expressed by the petitioner, the learned CGC was asked to obtain instruction. Accordingly, Mr. Gupta has obtained written instruction dated 35/2023 and placed the same before
Clause C, my lord.
before the court. Full stop. A perusal of the reflection made in clause C of the written instruction dated 35/2023 leaves no room for doubt that the petitioner will be entitled to receive equal medical treatment, if not better treatment, at the composite hospital at Bangalore. Full stop. It is also to be noted herein that the petitioner had joined the present place of posting at Guwahati in the month of December 2018. And by now, she has completed more than 4 years in the same station. Full stop. As per the transfer policy guideline of the CRPF, a normal tenure in a static and peace station is for 3 years. Full stop. Mr. Gupta submits that both Guwahati and Bangalore are peace stations. Full stop. If that be so, there is apparently no violation of the transfer policy in this case. Full stop. Although Mr. Vedguru has submitted that his client is entitled to at least 8 years of posting at a peace static station. Since there is no dispute about the fact that both Guwahati as well as Bangalore are peace static stations, even the safe policy directive does not appear to have been violated in the present case. In view of the above, this court does not find any good ground to entertain this writ petition. First up, however, taking note of the facts and circumstances of the case in its entirety, the petitioner be granted 1 month's time with effect from today to join in a new place of posting. With the above observation, this writ petition stands disposed of. Copy of the written instruction dated 30/5/2023 we retained in the case report.
My lord, there's a small prayer, lordship. My representation is pending before the DIG lordship. Page 18.
No representation is pending. my lord.
It's lordship, the page 20.
This is second representation. First
With
representation.
the
of-
above observation, if the petitioner faces any difficulty pertaining to the quality of medical treatment, it will be open for her to submit appropriate representation before the authorities, ventilating her grievance in the matter, in which event the authorities would consider the difficulties, if any, faced by the petitioner and take appropriate remedial action.
Much
With the above observation.
Lordship. It's matter not issuing release order, but in the meantime, yesterday, they have issued the release
Release
order.
order been issued.
That is a matter maybe disposed of.
All right, Mr. C. Borwal and counsel for the petitioner submits that yesterday, that is give the date, the respondents have issued the release order in favor of the petitioner and therefore the petition has become infectious. Mr. R. Gogoi, learned departmental counsel is present and has confirmed the same. In view of the above, this writ petition stands closed.
Another matter is the same. Next matter also.
Next matter, same order.
May I request
By keeping the release order dated
dated 30th, yesterday, 30th/5 of
So
2023.
in the record of this,
What
case.
that
Same
is,
order,
what that is sample.
please hand over.
Obliged, Lordship.
Same. Order.
May I please, your lordship, my lord, page number 34. My lord, the chief executive officer had directed for an inquiry on the allegation of some social media, my lord, footage. And on the same day, the commissioner terminated, my lord,
So
pending.
there are some other matters fixed. Where is it?
Lordship, we take instruction but need more time. So Lordship,
Sorry?
Lordship, we will take instructions, but instruction not received, so need more time.
When are the other matters fixed? Yesterday, I think Mr. K. Chaudhary was, NRD, as Doctor was there. You find out when the other matters are fixed. We list it accordingly. Heard Mr. M. J. Kadil and counsel for the petitioner, also heard Ms. N. Bora, learned standing counsel PNRD Assam, who prays for some more time to obtain instruction. In the meantime, it has been brought to the notice of this court that similar matters pending before this court have been fixed for consideration on this date. The registry therefore lists this case again on so and so as a fixed item.
The stigmatic order is
Huh?
passed, the stigmatic order is passed,
Yes,
my lord.
yes.
My lord, some protection may be given, my
Yes,
lord.
on the next day, other matters are fixed. Similarly, same matter.
Then-
You find out from Mr. S. Datta when is the date. S. Datta's SC PNRD knows.
Maybe.
Yes.
My lord, is the second round of litigation, my lord. My lord, what happens, my lord, the petitioner, my lord, is a bachelor in veterinary science, my lord. And my lord, on the 2022, my lord, July, advertisement was issued, my lord, for recruitment of, my lord, veterinary officer. And then that advertisement, my lord, upper age limit was 38 years. My lord, petitioners being the over age, my lord, they submitted one representation, my lord. And their case was that, my lord, that age should be condoned, my lord, in pursuant to a notification dated 3/5/1951. And my lord, in the strength of my lord, the interim order, the petitioners appeared before the interview, and accordingly, my lord, on 23rd of November, my lord, the result was also announced. And in my lord, in the said result, my lord, one post was reserved, my lord. This my lord. Yes, my lord. Page 49, my lord, serial number 62, subject to the final order of the Honorable Guwahati High Court. So one post was reserved for, my lord, and subsequently, my lord, on 2022, my lord, that petition was accordingly disposed of, my lord. Lordship, my lord, relevant portion at page 55, my lord. May I read, my lord? Page 55, my lord.
Yes.
Second paragraph, my lord. All the petitioners herein intend to participate in the selection process pursuant to advertisement number 13 of the 2022 dated so and so, issued by the respondent APSC for filling up 162 numbers of post of veterinary officers, block veterinary officers, class B and class 1 junior grade in the animal husbandry and veterinary department. The upper age limit as per advertisement is 38 years, and all the petitioners are above age of 38 years. In the circumstances, the petitioner had submitted a representation dated 30th of July 2022 before the Secretary to the Government of Assam in the Animal Husbandry and Veterinary Department for suitable relaxation of their age limit. The respondent in the Personnel B Department have filed an affidavit in opposition dated 1/12/2022, wherein in paragraph 4 it is started as extracted. Presently, the upper age limit for entry into class 1 and class 2 posts under the state government is 38 years for general category candidates, 43 years for SC/ST category candidates, 40 years for ex-servicemen candidates, and 48 years for persons with benchmark disabilities candidates. Other than this, there is no further provision for giving age relaxation at present. A reading of the extracted contents of paragraph 4 of the affidavit in opposition of Personnel B Department makes it discernible that it is the view of the Personnel B Department that apart from the provision that upper age limit is 38 years for general category candidate, 43 years for SC/ST category candidate, 40 years for ex-servicemen candidates, and 48 years for persons with benchmark disabilities candidates. No further provision for age relaxation is available. The said statement of Personnel B Department appears to be inconsistent and incorrect in view of the notification dated 3/5/1951, which provides for a particular procedure for relaxation of upper age limit in given individual cases. It is also taken note that the notification dated 3/5/1951 had been accepted by the judgment of this court dated 3/8/2015 in WPC number 845 of the 2014 and others. As there is a provision of law for relaxation of upper age limit, we require the petitioners to file individual representations before the head of the department, that is Animal Husbandry and Veterinary Department, giving their own individual reasons as to why the respective upper age limit should be condoned. Upon such individual representations being made for relaxation of the upper age limit, the head of the department, that is the commissioner, shall pass individual reasoned order within a period of 15 days from the date of receipt of such individuals representations. Their petition disposed of as indicated above. On the basis of that, we have submitted a representation and on 27/12, annexure I, my lord.
So what has happened after this
Then, my
representation?
lord, impugn order was passed on, my lord, on last annexure 60, page 61, my lord.
Hmm.
May I read, my lord? Madam, with reference to subject cited above, I am directed to inform you that the department have obtained the views of personnel B department in connection with your petition for relaxation of upper age limit. The
So
view
it is a reiteration of the same.
same, my lord.
Who is the officer? He has to come down. This is a contempt straight away. The High Court says this view is not correct. So take a fresh decision. Then the officer
Ito,
again does the same thing.
We are only relying upon the personal department, my lord.
That's all. You have nothing more to say?
No further instruction, my
All right.
lord.
Then we'll call the officer. This is the stand of the departmental counsel. Who is the officer? Heard Mr. A. Sharma, learned counsel for the petitioner. Peruse the statements made in the writ petition. Full stop. It appears that the representation dated 27/12/22 submitted by the petitioner has been rejected for the second time by reiterating the same views of the personnel department, based on which the earlier representation, personnel B department, based on which the earlier representation submitted by the petitioner and the other selected, other interested candidates, which was set aside by the learned single judge by order dated 2012-2022. Full stop. A plain reading of the speaking order dated 11/4/2023 not only indicates that there has been total complete non-application of mind in this case, but even but since the order which has been set aside by the learned single judge has been reiterated while disposing of the representation submitted by the petitioner, the stand of the officer appears to be contumacious, not contemptuous, contumacious on the face of the record. When the query was put to Miss
MM Kotogi.
MM Kotoki, learned standing counsel, Department of Agriculture, she did not have any submission to offer. Under the circumstances, this court is left with no option but to direct personal appearance of the officer, namely Sri Abhijit Borua, IAS, Deputy Secretary to the Government of Assam, Animal Husbandry and Veterinary Department, to appear before the court and explain his conduct as is reflected from the speaking order dated 11/4/2023. A copy of this order be communicated to Sri Abhijit Borua by special messenger. This matter is fixed. This matter be listed again on 14th of June as a fixed item.
Same, madam.
Same, madam.
Same. 11 is same.
Same. List along with so and so, that's all. Heard so and so, so and so. You are appearing for the government? Miss MD Bora, and the government advocate is present. But it's very surprising that you are having nothing to answer. No answer to be given. And next matter to list along with so and so.
Yeah, please, your lordship. Well, the petitioners here are working as Turner in borderhood organization. They had the post of Turner had earlier the promotional avenue to the charge mechanics. By impinged era that the promotional avenue has been closed, and for that they are stagnating. So, my lord, the relying on the law laid by the Honorable Supreme Court, the right of consideration for the next promotional avenue, blockage of promotional avenue is arbitrary. And for that, my lord, recommendations also made by the manager to make their promotional channel, but that has not been acted on. So this is my lord praying for notice.
Notice, heard Mr. S. Nath, learned counsel for the petitioner, peruse the amendments made in the petition. Mr. UK Goswami Lalit CGC prays for some time to appeal instruction in the matter. NOM 6 with since Mr. Goswami has appeared in accepted notice on behalf of
All the respondents.
all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the Learned Department Council. Requisite in numbers so as to enable him to obtain instruction. Learned Council for the petitioners, 8 weeks could do. So as to enable him to obtain instruction and file affidavit. Let the matter be listed.
Item number 9, your lordship has similar matter pending, your lordship, and contractual employee. Just your lordship has directed to list the along with the, and I got the number, your lordship, so matter may come.
What is the number? Give them.
Of 1785, 2022.
1785 of 2022. Fixed on?
Fixed tomorrow, your lordship. Along with other matters are also there. This matter, apply for it.
May it please, your worship. Here, my lord, the petitioner was engaged as a master roll laborer, my lord, way back in 1998, my lord. Thereafter, my lord, he was terminated from this engagement, my lord, on 2000, my lord. Thereafter, he filed, approached this honorable court, my lord, by filing a petition, my lord, which is at page, my lord. The order of the court, my lord, is at page 23, my lord. Order dated 9/4/2012, my lord. Thereafter, my lord, official letters, my lord, one after another has been issued, my lord, till date, my lord, no action has been taken in this regard, my lord.
So has the gate for post been advertised?
Yes, madam.
Where is the advertisement?
Advertisement, let I have not alleged, my lord.
Then
Yes,
I'll not
because, my lord, as because not the. In the meantime, my lord, he has closed the age limit, my lord. Now, my lord, he is 52 years old, my lord. As my lord, in the advertisement, my lord, his online application could not be.
No, he cannot be appointed now.
Yes, my lord.
He cannot be
As
appointed.
because, my lord, his age is over, my lord.
That's right, it is over now. There cannot be direction to appoint someone without an advertisement. or anything.
Yes.
The Learned Single Judge has considered, that means if there is a recruitment process, if
Yes.
he applies,
That will be
then
considered
his candidature will be considered by giving weightage to his past experience.
yes, my lord.
But there is no advertisement. No advertisement has been issued.
Yes.
So then what can be done?
Therefore, my lord, several advertisement will die.
No,
Good, my lord. But
nothing.
his application,
Sorry,
was not-
this,
his application was not accepted.
his application will not be accepted because
Yeah.
he is overaged.
Yes, my lord.
You first submit an application of 52 years delay, age
Yes.
cannot be condoned. This is what, 12 years? What is the upper age limit?
This direction was of the year 2012, Lordship.
Thereafter, my lord,
Now it is 2023, Lordship. In the meantime, Lordship, so many advertisements have been issued, Lordship.
in the meantime, my lord, kindly see the.
No, in fact, Lordship,
Page
he
number
never
20,
applied,
26
Lordship. He
onwards,
never
my lord.
applied.
Letter.
All right, heard Mr.
This one after
S. Islam,
another.
Learned Counsel for the petitioner. Also heard Mr. P. Nayak, Learned Standing Counsel,
PW, Lordship.
PW.
1 to 7.
Assam, appearing for the respondent numbers 1 to 7. The writ petitioner herein is seeking a direction upon the authorities to appoint him in any grade 4 post. This prayer
Yes.
of the petitioner is
Yes,
apparently
31 also, my lord. The vacancy position has been, my lord,
apparently based on
indicated, my lord, in this case.
the order dated
9/4/2012.
9/4/2012 passed in WPC number 1746/2012, wherein this court had passed an order granting liberty to the petitioner to apply for the grade 4 post if and when any fresh advertisement is issued, and the authorities were also asked to provide due weightage to his past experience. Full stop. Mr. Islam submits that the online process is not accepting the application of the petitioner since on the ground that he is overaged. Full stop. The petitioner's counsel submits that the present age of the petitioner is 52 years. Full stop. Mr. Nayak, learned counsel for the learned departmental counsel submits that since the year 2012, number of advertisements for filling up grade 4 posts have been issued by the department.
Not just PWD lots, other department also.
By the PWD and other departments in the state of Assam, but petitioner did not submit his application in response to any of those applications, any of those advertisements. Full stop. The upper age limit for appointment in government service
Offline application. Madam.
is 38 years. And the age of the petitioner today is 52 years, and therefore there is no scope of relaxation of upper age limit as well. On such ground, Mr. Nayak prays for dismissal of this writ petition. First up. It is to be noted herein that the direction of the learned single judge issued on 9/4/2012 was only to give due weightage to the past experience of the petitioner if he applied for a grade 4 post pursuant to any advertisement issued by the department. Full stop. There was no direction to appoint the petitioner against any grade 4 post. Full stop. If the petitioner is 52 years old, no direction can be issued to the respondents to accept his application, since the upper age limit for applying for a government job today is 38 years. Full stop. Moreover, the petitioner has approached this court nearly 11 years since the order dated, it's 11 years after the order dated 9/4/2012 was passed, and there is no explanation as to why.
Official letters my lord, have been issued my lord, one after another. My lord.
Did
Kindly
not
see the page number
approach the
31 my
court
lord.
Earlier,
In
if he had in fact submitted his application for appointment in a grade 4 post pursuant to advertisements notices issued by the departments from time to time. Having regard to the peculiar facts and circumstances of the case, as well as the current age of the petitioner, this court is of the opinion that there is no scope of granting any relief to the petitioner in this case. The writ petition is accordingly held to be devoid of any merit and is dismissed. Yes, next matter, please. Yes.
May it please your lordship.
Yes.
Lordship, in response to an advertisement, the petitioner appeared, lordship. And thereafter computer test, he qualified the written examination, lordship. Thereafter physical test was conducted.
So there are similar orders.
Similar order, my lord, in writ petition.
So where is the order?
2641 I have.
Also the order.
2854 of 2023. Your lordship has all.
Disposed of.
I'm deeply obliged.
Yeah, please, Your Lordship. Hello, this matter is relating to compassionate appointment and my claim to this lordship has been rejected by the DLC. That is your lordship will find page 45. So the similar orders will
Yes,
pass.
my lord, lordship, the writ appeal, my lord, there is a delay condition petition. In this condition petition, notice has been issued already.
Also, but there's another point, that's 2 points on which this petition was rejected. Your Lordship. There's also a second point, at page number 45, your Lordship will see. The decision part is there. First one is 3 years, yes, true. Second one is about, there be no 5%, no vacancy in the 5% quota. Relying on for 14A1 of the OML. So it's not only the case of rejection on the part of only one ground. So that.
So far the second ground is concerned. My lord, this is a small cadre establishment where lordship 3-4 posts, I think lordship in the category of grade 4 and grade 3 lordship. In that lordship circumstances, there is a. Then we will issue notice at this.
Lordship, that's what.
Mr. M. Khan, Lange counsel, has appeared for the petitioner. It agreed by rejection of his application for appointment on compassionate ground on the twin grounds of non-availability of 5% quota of 5% quota of vacancies for appointing candidates on compassionate ground and also due to shortfall of minimum 3 years of balance service period left in the credit of the petitioner's father on the date of his demise. The instant writ petition has been filed. Mr. C.S. Hazarika, Learned Government Advocate Assam, prays for some time to obtain instruction in the matter. NOM 6 weeks. Since Mr. Hazarika has appeared and accepted notice on behalf of
2 and 4.
numbers 2 and 4 and Ms. Bora,
3 and 5.
Ms. MD Bora, Land Standing Council Cooperation Department Assam, corresponding numbers 1, 3 and 5. Service of notice is deemed to be complete in this case. Extra copies of expedition requisite in numbers be furnished to the learned department council so as to enable them to obtain instruction. Yes.
May I please, Lord?
Yes.
My lord, in this case, my lord, petitioner are the residents of village Boga, my lord. The Gaubada of their village died on 2021 to 2021. It was wrongly in synopsis 22 have appeared, my lord. And thereafter, in the meantime, though a recruitment process initiated, my lord, and one person was selected, but his selection has been cancelled, my lord. And since the death of the earlier Gaubada, my lord, no Gaubada has been appointed till date, my lord.
So what is your right?
Right, my lord?
What is your right? There may be Gaubura, there may not be Gaubura. What the writ court has to do with that?
My lord, since they have initiated the process, my
You
lord.
go and approve your.
My lord, we have filed representation, my lord.
No, you approve your political leader. Will not entertain these petitions.
Yes, my lord.
You ask the MLA, local MLA to take up the issue. This is not for the writ court to do it.
My lord.
Yes, heard Mr. AHMR Chaudhary and counsel for the petitioner. Peruse the statements made in the writ petition. As per the case projected in the petition, the previous government Gaubura of village Ghoga under Borkhetri Revenue Circle, Mukalgua had died on 21/2/2022.
20, my lord, it is typographical mistake.
21/2/2020.
20, my lord.
Thereafter, an advertisement notice dated 02/11/2020 was issued for appointment of a new Gaubura pursuant hereto. One Muhammad Yunus Ali was selected, but his selection was cancelled by the subsequent order dated 21/10/2022. Full stop. According to the petitioners, now the petitioner's grievance is that the village is running without a Gaubura since 21 to 2022, as a result of which the villagers are facing difficulties. Full stop. Although the petitioners had submitted representation dated 04/05/2023 before the Deputy Commissioner in Nalbari to appoint a Gaubara, no action has been taken in the matter till date. Hence this read petition. Ms. M.D. Bora, Learned Government Advocate Assam, and Mr. S. Datta, Learned Standing Council Revenue Department Assam, have submitted that the matter has been looked into and appropriate action will be taken for appointment of Gaubara in due course of time. First of, after going through the readings in the read petition, I do not find any fundamental or legal rights of the petitioners that can be enforced in this read petition. First of, it is no doubt correct that when there is provision for appointment of a government Gaubura, the respondents should do the needful to appoint a competent person in the post of Gaubura. Full stop. However, if there is failure to do so, the same is essentially a matter which lies in the realm of governance, and therefore the read court would not ordinarily venture into such matters unless a specific case is made out of violation of right, violation of any right of the petitioners. First of, in view of the above, by granting leave to the petitioners to approach the appropriate authority, including the local political representative, for taking remedial measures in the matter as may be warranted under the law, this read petition stands closed.
Madam.
Item 17.
Refuse the lordship. My lord, at this stage, notice may go out lordship them regarding.
What is the matter?
Regarding lordship, he is working since 1994. Page 33 lordship, there was a judgment in his favor, in which the state government has agreed to enlist the employees to health and accidental and other benefits. Lordship. That was not paid to the petitioner. So at least some security lordship.
Yes, we'll issue notice and heard Mr. K. Majumdar, Learned Counsel for the petitioner. The read petitioner claims to be working as a night chowkidar since 6/4/1994 under the Department of Handloom and Text, under the Directorate of Handloom and Textile from Assam. First of, aggrieved by inaction on the part of the authorities to regularize his service, the instant read petition has been filed. First of, Mr. P. Nayak, Learned Standing Council.
Lordship, I'm appearing for respondent number 4, Lordship, Finance Department.
Finance, and Miss, your name, please?
Miss Sushil Sanma,
Huh?
on behalf of Mr. Ardhar.
And Mr. Ardhar, Standing Council, Handloom and Textile Department, Handloom, Textiles and Agriculture Department.
I'll take by the.
Appearing for respond number 1, 2, 3. Have prayed for time to obtain instruction in the matter. Issue notice of motion returnable in 8 weeks. Since the respond numbers 1 to 4 are already represented, no formal notice is required to be sent in this case. Extra copies of the read petition be furnished to the Learned Departmental Council. Stop petitioner to take steps for service of notice upon respond number 5 by registered post with AD within a week from today.
Item 18.
May I please, your lordship.
Lordship, petitioner was initially engaged in the accredited engineer lordship in the year 2010 lordship, and his
Dismissed without any notice.
yes lordship.
Tomorrow.
It's covered lordship. I placed
Yes.
a
Heard Mr. So
Judgment.
for the petitioner, also heard Ms. N. Bora, Learned Standing Council. This court has been appraised that similar matters are fixed tomorrow.
May I show one thing, lordship? Because lordship comes to page 48. So though I am not the standing counsel for the department, but even then.
Yes.
I don't think lordship it's not a stigmatic order, I think, lordship. It's a contractual employee. He was not found doing his work properly according to lordship. So there is no such specific allegation.
Of course, that is a stigmatic order.
There is
Any
a-
order which has the effect of termination or dismissal or
No, Lordship,
removal,
they are contractual according. to
maybe
Lordship.
there are judgments.
Yes, yes. Otherwise, Lordship, but
are
in the
judgments.
show cause notice, the allegation should have been specific. Orders, দেখা পাইছো।
There are judgments, even contractual, temporary, everything
Yes,
comes
yes.
under 311.
But after expiry of that contractual
Even
period,
that,
we
even
can remove him, but if it is stigmatic, we any allegations is against him. In that case, Lordship, the enquiries must be there. But here, Lordship, there is no such any specific allegation. I am only on that.
No, any order, Mr. Sharma,
Lordship,
you please read those
Lordship.
judgments. You will like
No,
it.
no, Lordship.
It's better to know the law, how it is
Lordship.
evolving. There are decisions of the Supreme Court. If you want, I can give you the citation.
Lordship.
Wherein it has been clearly stated that any order which has the trappings of an order of termination, dismissal, or removal, even if it is of a temporary employee, a contractual
Lordship.
employee, has to be compliant with the requirement of
Lordship.
Article 311 of the Constitution of India. Whether the post is filled up, vacant, doesn't matter. Otherwise, it gives a complete arbitrary sword in the hands of
No,
the executive.
otherwise,
They
yes,
can
Lordship,
just
but-
cut people and throw them.
Lordship.
Difficult. Tomorrow. And we'll deliver the judgment tomorrow.
Itu tomorrow night.
So it is second round of litigation, my lord. Earlier, this court, my lord, disposed of the case of the petition, my lord.
2009.
Yes, my lord.
Mr. Islam, why do you come with bad cases
Yes.
so frequently? We'll have to
Earlier,
discuss.
my lord, the petitioner was selected by the
Nothing can be done,
GHC, my
nothing.
lord. Thereafter, my lord, the state level committee, my lord, has rejected the case of the petitioner, my lord, on the
2000,
ground
right?
of non-availability of the vacancy, my lord.
No, it cannot be done. Even if a vacancy is available, your case cannot be considered.
Yes, my lord. That-
Because
from
that
period
stage is
to
gone.
this period, my lord, he is
Gone,
running
gone,
on the.
gone. That is gone.
At least, my lord.
No, sir. On 2015, Lordship, it was rejected, Lordship. That's why, Lordship,
Thereafter
again
he
approached
approached
the
this court,
honorable
my
court, Lordship.
Thereafter, he approached this court, my lord, by filing a writ petition, my lord. Which is at page, my lord, 45, my lord. 45, my lord. Relevant portion, my lord, is at page, my lord. 47.
Court directed, Lordship, if it
Yes.
finds that the petitioner can be considered for the compassionate appointment, Lordship.
Now, after rejection,
That's a rejection.
where is the order of the court?
6 years,
Where is the earlier order of the court?
My lord, page 46, my lord.
For 6 years, he has come, Lordship. She has come, Lordship.
Nothing can be
19.
done.
Yes.
So what order has been passed after this court order?
Thereafter, my lord, this order, my lord, the petition, my lord, approached the office of the respondents, my lord, by filing representations, my lord.
It cannot
But
be considered.
Till date, my lord,
No,
no
it
steps
cannot
have
be.
been taken on
They
the.
will not. If they do it, we'll call them.
Yes.
If they entertain applications after years, then we will call them and ask them to tell us what principle they are following. This has to stop. Compassion period is over, compassionate appointment claim is over. Nothing can be done. Everybody would want that people who have lost the bread earner should get the relief. But if it is happening in the right time, yes, certainly. This cannot happen after 20 years, 15 years, 12 years.
In fact, my
Heard
lord,
Mr. S. Islam, learned
petitioner
counsel
was
for the
selected by
petitioner.
the state
No.
DLC, my lord.
Nothing.
Thereafter, my lord, his-
DLC does not
her case
select,
has been
DLC recommend.
rejected, my lord.
Also heard Mr. H. Chakravarti, learned government advocate Assam.
Respondent 2, 6 and 8, Lordship.
Respondent numbers 2, 6 and 8. Ms. M. Kotoki, learned standing council, agriculture department, Assam. has appeared for-
1, 3, 4 and 5.
Respondent numbers 1, 3, 4 and 5. Full stop. Being aggrieved by rejection of his, aggrieved by non-consideration of his case for appointment on compassionate ground, the petitioner has approached this court for the second time by filing the instant writ petition. Full stop. The facts of the case, comma, in a nutshell, comma, is that the petitioner's husband, namely Paresh Mohan, had died in harness on 15/8/2009 while serving as a lower division assistant in the directorate of, in the office of additional director of Animal Husbandry and Veterinary Department, bracket Hills, bracket close, comma, half log, poster. After the sudden demise of the sole breadwinner of the family, the petitioner submitted an application for appointment on compassionate ground against a grade 4 post. The application submitted by the petitioner was also duly recommended by the DLC of Dimahasa, bracket Haflong, by its resolution dated 23rd August.
Yes.
23rd August 2011. However, the application of the petitioner was rejected by the state level committee, bracket SLC, in its meeting held on 30/12/2015. Full stop. Thereafter, the petitioner had approached this court by filing WPC number 6077/2021. Full stop. The learned single judge had disposed of the writ petition by order dated 17/11/2021 with a direction upon the respondents to consider her representation in terms of paragraph 15 of the OM dated 1/6/2015, which permits the authorities to consider the application against vacancies, application for compassionate appointment against vacancies in other departments if such vacancies are not available in the parent department. First step. The learned single judge had, however, noted that there was delay on the part of the petitioner in approaching this court. First step. Pursuant to the order dated 17/11/2021, the petitioner had submitted a fresh representation. However, no action has been taken on such representation. Hence, the present writ petition. First step. Mr. Chakravarti submits that the case of the petitioner is hit by delay and laches. Moreover, an application submitted in the year 2009, is it?
Lots, 9.
She submitted an application in 2009.
2009 lots.
9.
DLC,
And
DLC recommended on 11 lots.
That's
So 11.
recommended by the DLC in the year 2011 cannot be considered at this point of time. Full stop. What is to be noted here in that the scheme framed by the government of Assam for appointment on compassionate ground is aimed at providing immediate relief to the family of the deceased government employee, which has lost its sole bread earner. Full stop. The die in harness scheme within courts does not confer any indefensible right upon the family member of the deceased employee to seek employment in government job. Full stop. In the present case, as noted above, the husband of the petitioner died in the year 2009 and her application for appointment on compassionate grounds had been rejected by the SLC
2015.
in the year 2015 on the ground of want of vacancy. Full stop. Therefore, at this point of time, the petitioner's application cannot be considered against current vacancies. Since in the meantime, a number of new applicants would have a right to be considered for appointment against those vacancies. Moreover, the scheme of compassionate appointment floated by the government of Assam had been withdrawn way back in, what is the date? Why is it-
17, Lordship.
What is the date? Withdrawn on so and so date. Therefore, when the order dated 17/11/2021 was passed by the learned single judge, the scheme was not even in vogue.
14 September 2017, Lordship.
14 September 2007. So, under the circumstances, the question of considering the petitioner's representation for appointment on compassionate ground did not arise in the eye of law. Full stop. In view of the reasons recorded herein above, this court is of the opinion that there is no merit in this writ petition. The same is accordingly dismissed.
Obliged.
May I please, Lordship? Lordship, the application of the petitioner was considered by the TLC Lordship. But in the SLC Lordship, it is rejected, Lordship. By my note dated 31/12/2018, Lordship. SLC is at page 16, Lordship.
But the scheme is no longer there. There is no scheme that is withdrawn on 14/9.
Lordship.
Today, what order can be passed?
Lordship, in that SLC Lordship, the reason it has been
Mr.
mentioned.
Mr. What is your name?
And Honk, Lordship.
You have a good case. Let's take it.
Lordship.
No direction can be passed because the scheme is not there. They followed.
Lordship.
What can be done now? The scheme for appointment on compassionate ground has been withdrawn by the government.
Lordship.
So
But
the appointment is to be made under the scheme, right?
Lordship, Lordship.
Scheme is gone.
But that scheme is gone later on, but while the father of the petitioner was expired, Lordship, at that time, Lordship, the scheme was available, Lordship.
Yes.
Lordship, and while considering the case of the petitioner before the DLC, Lordship, DLC considered, Lordship, in the Lordship, 1/3/2017, Lordship. 1/3/2017, Lordship. DLC is at page 11, Lordship. In the grade 4 post, Lordship. Now in the SLG 2018 only, Lordship. Lordship, the case of the petitioner.
What do you have to say?
More than anything else, apart from what has happened, 5 years delay is there right now, as we can see also. 18, this is a SLC 2018 matter, and he is coming now. Apart from anything else.
Lordship, but after 18, Lordship, there is a COVID period and all that. So
No, we'll reject it. Heard Mr. N. Hawk, learned counsel for the petitioner. The facts of the case come up in a nutshell is that the father of the petitioner had expired on 19/9/2015 while in service. Having lost the sole breadwinner of the family, the petitioner had submitted an application dated 5/10/2015 seeking appointment on compassionate ground. The DLC of Kamrup district had considered and recommended the case of the petitioner for appointment on compassionate ground against a grade 4 post. However, the state level committee, SLC, by the minutes of meeting held on 31/12/2018, had rejected the case of the petitioner on the ground of wanted vacancy. In the meantime, the scheme of appointment on compassionate ground, the scheme permitting appointment on compassionate ground as floated by the government of Assam had been withdrawn with effect from 14/9/2017. After a lapse of nearly 4.5 years from the date of rejection of his prayer by the SLC, the instant writ petition has been filed. Full stop. Mr. C.S. Hazarika, learned government advocate Assam, and Mr. P. Nayak, learned standing counsel finance department Assam.
PWD.
PWD Assam have questioned the maintainability of the writ petition on the ground of delay and laches. Full stop. The only explanation for delay as furnished by the petitioner's counsel is the outbreak of COVID-19 pandemic. However, it is a matter of public record that the pandemic had occurred in the month of March 2018 and was practically over within 1.5 years. Full stop. The present writ petition has been filed only on 29 May 2023. Full stop. Be that as it may, the fact of the matter is that the scheme for appointment on compassionate ground was floated by the government of Assam so as to give immediate relief to the family member of the deceased employee, which has lost the sole breadwinner. Full stop. The petitioner's father had admittedly expired on 19/9/2015, and since then, for almost 8 years now, the petitioner has survived without a government job. Full stop. The aforesaid fact, coupled with the delay in approaching the court, demonstrates on the face of the record that this is not a fit case for consideration. This is not a fit case for this court to interfere with the minutes of the SLC dated 31/12/2018, which has rejected his application for want of 5% quota. Situated thus, it is held that his writ petition is devoid of any merit. Certainly the court will discuss.
What's it, matter may be possible for the time being, Yugosami is appearing and he is in court number 1. That's it.
Is what is the case?
Lordship, it's a transformator.
Back pain.
You are back.
Hot water bag.
And Lordship, one aspect is there. that
Use
is
a hot water bag, your client will be
For
fine.
avoid forward bending, massage, heavy work, lifting, weight, squatting, etc.
All many
So
of,
that is
lot of people sitting in this courtroom will have worse problem than.
as per instruction of the doctor, he has to go under for surgery also if he's not recovered. So that is one
But
aspect
how
of the
does,
matter. At
how
least
does being in Guwahati help?
GNRC hospital, his treatment is
We
going
will
on
and
there.
we'll ask them to make available proper treatment as and when.
Other concerned doctor. And apart
Yes.
from that, another one that is 4 months baby is there. And post-operative, this medication is going on. of his wife.
Normal part of
Yeah,
normal.
yes, fine. So basically, this is the,
Yes. There's nothing.
so it is here at page 23.
When was the petitioner posted at Guwahati?
He posted it Guwahati on Lordship 17 April 2019, 2019 euros.
17?
17 April 2019 euros.
So 4 years, 4 years
Yes,
has passed.
He has crossed 3 years, Lordship.
54.
But that follow-up medical, that checkup and everything is going
He's
on.
posted now where?
He is posted at Lordship.
There is a hospital there. but
This
this
is in ONGC Nazira. But the facility of the GNRC, like that would not be available. And so far the concerned doctor is concerned. That is a problem. That is why he was seeking for some deferment, Lordship, at least for some time, so that he can complete.
Yeah,
his-
he
he can
submitted
get-
representation.
He submitted his representation, your Lordship.
What has happened to
Fine.
it?
At page 42, annexuary. So citing this ground,
What order has been passed in the representation?
Lordship, I'm not in this case. Lordship, Yugosami is appearing. He is in court
All right, call him.
1.
Wait.
Yes.
Item 55. Where is the order? Where is the order? Similar order?
Yes, earlier order, page number 54, Lordship. I have annexed it, Lordship.
Page number 54.
54, Lordship.
And who is the CGC appearing in this case?
Lordship, here just one difference, Lordship. The petitioner has not appeared earlier in similar recruitment process, but he has a requisite height. He has went to the Barpeta Medical College Hospital.
Who is the CGC here appearing?
Yeah, my lord, the engaged learned counsel is on legs in court number 1.
Who is the counsel?
Harish Gupta, H. Gupta.
All right, call him. Yes. Yes.
Yes. Lordship, just difference is that petitioner he has not appeared earlier similar recruitment process. On being deprived by the respondent authorities, he went to the Barpeta Medical College, whether his height is exact 165 centimeter or not. The Barpeta Medical College and Hospital and Lordship Bongaigaon Civil Hospital issued a certificate of the petitioner on 165.3 after measurement, 165.3, and beginning the test also.
So petitioner participated in the recruitment
Yes,
process.
yes, Lordship, Lordship.
Yes.
He was
You
intended.
prefer an appeal, that's all.
Yes, Lordship, I may be allowed to appeal, Lordship.
You had undergone physical standard test
Yes, physical test.
and physical efficiency test.
Efficiency, he was qualified, Lordship, efficiency test, Lordship. But they have also declared him unqualified. Or respondent this. BSF.
So you are appearing.
Lordship, I can, Lordship. Lordship, you can prefer appeal, Lordship, as per Lordship's earlier direction. Here, Lordship.
You will appear. Who will appear?
Lordship,
There is a provision for appeal.
it-
They have not appealed, they can appeal.
Disposed of. Then there are other, which are the other matters?
56, 57, 58.
57, Lordship, I am appearing.
The 57 K go.
56 Lordship.
56
56.
R Devi. GC.
In 56 Lordship, they have filed appeal and
But not allowed it.
yes, rejected it.
They have not accepted it also. Lordship.
Then now it will be. So Mr. Gupta is in 55, Ms. R Devi is in
56.
56, Mr. K Gogoi is in 57.
Lordship, Lordship.
And what is 58?
58 is also similar, Lordship.
Who is in 58?
58, I can, Lordship.
Mr. K Gogoi in 58. Just see whether there are multiple petitions.
58 is not this.
50.
No, all single petitions. All
No.
single. Disposed of. Similar order. Yes.
That is IA 449, Lordship. interim order is at page, starts from page 10, lordship relevant for part from page 11. The petitioner's second paragraph, lordship, that was the main issue. The petitioner case is that she was forced to sign a voluntary retirement letter dated so and so 2012. This date is relevant. However, on 21/12, that is on the very next day, the petitioner withdrew the above letter dated so and so, notwithstanding the same, the treasury officer, Zorat Treasury, issued the impugned letter dated 28/2/2020, stating that the petitioner voluntary retirement letter had been approved by the authority. As such, she was allowed to go for a voluntary retirement. That was the issue, lordship.
So it was withdrawn.
According to her, it was withdrawn, but in our record, there is no such withdrawal letter, lordship. And if your lordship comes to our story,
Where is the letter of withdrawal? Is it a part of the record?
the writ petitioner has annexed it, lordship.
Page 24, my lord, in the writ petition.
So if the interim order is vacated, then she will retire.
Yes,
Then what will remain in the writ petition?
yes, lordship. So that interim order amounts to the final order, lordship.
But sometimes this order will
So,
have to
lordship,
pass.
lordship. For final disposal, lordship, it can be taken up.
Hmm.
Our this interlocutory application, it may be treated as an affidavit, lordship.
All right. heard
If
Mr.
your lordship
Yes,
wants to
yes,
hear it
H.
today,
Sharma, not today.
lordship.
Today you are ready.
I'm ready.
You are also.
I am also ready, but lordship, the time most probably 10-15 minute times will require, lordship.
We'll have it on a non-miscellaneous day. There is a judgment of this court.
Yes,
No,
yes.
I'll-
56C. Have you
Yes.
got it?
I got the judgment
You
and
have read
also
it?
that, my lord, Sangma case from Supreme Court, that was. Justice
Lordship.
Ratnayaka. Yes,
Read the judgments.
they threw staring at us.
No, whether that withdrawal letter, lordship, I am on that, lordship. I can show it from the record, from the writ petition itself, lordship, as because
Where is the order, letter of withdrawal? Let us see. Page number.
24, 20.
page number 24 is the typed copy. Then the vernacular one, which the petitioner has submitted, that is at page 27.
So there is 56C
Yes.
Yes.
talks about a time period.
Yes.
That is
3 months.
3 months.
Yes,
It will take effect only after 3 months.
lordship.
You
That,
can't,
that in lieu of,
ah,
yes, lordship, I
you
know.
can't do it before 3 months.
Yes.
It takes effect only after 3 months. So how could you have been, how could?
No,
she-
whether she has submitted that withdrawal letter, that is the thing. If she has not submitted that withdrawal letter, in that case, lordship, our this VRS, the imposition of VRS is applicable.
This
In
is the
lieu of
type
lordship,
copy.
this
Where is
3
the
months
original
notice
copy?
period,
My lord,
lordship, we have given.
Page 27, original withdrawal letter.
No, page 27.
Yes, in
But
vernacular.
is it, is it?
Writ
received?
petition, in the writ petition.
In the writ petition.
If they deny having received it, then what happens?
Kindly see the signature, page 28. The person who put
I-
his signature,
I
he
can-
sits with me since last 10 years. In same place we sit, it is his signature.
No, who is he?
He's Ajit Hajarika. He's one of the person who always received the documents. He's Ajit Hajarika's name. He and me sit together for 10 years, same place, like the
Oh,
way he's sitting.
Mr. Nath, 10 years you sit together or you sit separately?
No,
Has
the
nothing to
reason
do.
is, it is his signature, and now probably, my lord.
If
We'll
your
twist the
lordship
facts.
wants to hear it today itself, I can show. If your lordship may fix it another date, lordship, that's because my learned friend will get the handle if I disclose this thing,
Correct.
lordship.
Heard Mr.
I will place it before your lordship.
Sharma, learned senior government advocate Assam, appearing for the applicant. Also heard Mr. M. Nath, learned senior counsel, listed by Mr. A. Bhattacharjee, learned counsel appearing for the appeal petitioner. Mr. P. Nayak is present on behalf of the finance department.
Only my simple prayer is that lordship, because of this interim order, in spite of there being no any post, but we have to give her the salary. So lordship may kindly fix a early date, lordship. That is my only prayer, lordship.
By filing this IA, a prayer has been made for vacating the interim order dated 3/6/2022, passed by the learned single judge in WPC number 3664/2022. Full stop. It appears that the whole controversy revolves around the question as to whether having applied for voluntary retirement, come on, did the petitioner withdraw did the writ petitioner withdraw this petition on the next day, on the very next day, as claimed by her? Full stop. If the answer is in the affirmative, then the petitioner would succeed in the writ petition. However, determination of the aforesaid aspect of the matter would not only require this court to go into the record, to require this court to examine the records, but also enter into the merit of the case. Full stop. The said process would require a full-length hearing. As such, as agreed to by learned counsel for both the sides, and due to the urgency expressed in the matter by the learned government advocate Assam, the registry is directed to list this case again on 22nd of June.
Lordship.
22/6/2022.
22nd. My lord.
As a fixed item, directed to list the connected writ petition on 22nd of June 2023 as a fixed item, along with this IA, interim order passed earlier to continue till then.
Much obliged, Lordship.
Yes, filed an IA lordship for vacation of the interim order passed earlier. Lordship. I am the selected candidate lordship, and due to the interim order passed earlier lordship, my appointment has been stalled lordship.
Where is the order?
Lordship will find it at page 85 lordship. It starts at page 85. 87 lordship, the last paragraph. Considering the prima facie case till the next returnable date for one post each in the SC category simplicity.
You are reading from which page?
Page 87 lordship.
Yes.
The last paragraph lordship. Considering the prima facie case till the next returnable date for one post each in the SC category simplicity, SC persons with disabilities and SC will be not filled up. Lordship, in the next page. On the next date, the respondents may provide the court with the next necessary material as to what manner the aforesaid horizontal reservations had been made applicable. Depending on the material being produced, further consideration would be made as to the nature of the interim order that may be required to be continued with. We are deliberately not issuing notice in the matter and requiring the respondents to produce the records as to arrive at the further prima facie satisfaction on the manner. Lordship, that was what was the view of the court while passing the interim order.
I'm sorry.
Yes.
My lord has seen the order which I'm praying for a vacation. My lord, in the advertisement, there was a clear specification that 14 posts will be reserved for PH candidates. It was not, my lord, made category wise because they can't make it. It has to be overall. 14 posts were reserved. Subsequently, my lord, the list came, the select list came. In the select list, my lord, we are for my lord, hearing impaired, my lord. Sorry, my lord, visually impaired. There are only 3 visually impaired category candidates against the required 4 candidates. Now, my lord, I'm at serial number 318. I am an SC candidate with visual impairment. As per the, my lord, policy of the government, my lord, once this list is prepared, whoever that PhD is identified, whatever his caste is, my lord, he will be adjusted against that. And accordingly, my lord, I was adjusted against the SC quota.
So you mean to say within the PhD category, there will be further reservation for SC?
No,
then
my lord, it will be there will be no reservation for my lord any PH can. There will be overall. He can be at serial number 1. So my lord, you need not bring anybody more. This is horizontal, my lord. Say, my lord, he is at serial number 318. the man with that with that physical handicap. He happens to be a visually impaired person. He is picked up, my lord. Now he'll have to be placed in the against a post. That, my lord, will go with his category. My lord's judgment that is there. In that judgment, my lord, what had been done was they had categorized SC PW 4, ST PW 5. That's not the case here, my lord. If my lord can just come to the the select list, my lord, that will be clear, my lord. Page 76, my lord.
Page 76
Of the IA, IA 798.
Yes.
My lord would see after the first paragraph, number of posts, 320. My lord has got it.
Yes.
Reserve for women, RFW, 97. And PWD, 14. Out of that, visually impaired 4, hearing impaired 4, OH 3, and autism 3. Now, how do you place them? My lord, that the placing has to be done in terms of their merit position. At 84, my lord would find minding.
No. If a PhD category comes on merit, he will
Then
not be.
No, he will not be given that reservation. I'm not on merit, my lord. I can't come on merit. And that is the reason why I was accommodated against the SC post.
You are accommodated against an SC post.
Lordship.
But you mean to say you have been given the dual benefit of SC and PhD?
No, my lord, it's not that way. I am a PhD candidate. After the, my lord, entire select list is prepared, they'll have to, my lord, examine whether these 14 PWD candidates are there. They have come up on merits also, my lord. If these 14 candidates are there on merits, they need not make any further reservation, my lord. That's the end of the matter. Now, if it is not there, they'll have to provide for that. The provision is made, my lord, then they go and check up the list where this candidate is. When they spot that candidate with that physical impairment, my lord, they will place him. Now, to how to place him, that the policy is they'll place him against the reservation category he belongs. If he is an unreserved, he'll go against an unreserved post. If he is an SC, he'll go against an SC post. If he is an ST, he'll go against an ST post. And that policy is very much there, my lord. Page 98. This is the office memorandum of 22. My lord would come to clause 9 at page 100, my lord. I'll just take my lord through that, my lord. 9.1. Reservation for backward classes of citizens, that is SC, ST, OBC, MOBC, is called vertical reservation, and the reservation for categories such as persons with benchmark disabilities and ex-servicemen is called horizontal reservation. Horizontal reservation cuts across vertical reservation in what is called interlocking reservation. And the person selected against the quota for person with benchmark disabilities have to be placed in the appropriate category vis-a-vis SC, ST, OBC, MOBC, unreserved, depending upon the category to which they belong in the roster meant for reservation of so-and-so unreserved. To illustrate, if in a given year there are 2 vacancies reserved for person with benchmark disabilities, and out of the 2 persons with benchmark disabilities appointed, 1 belongs to ST and the other belongs to unreserved, then the SC candidate with benchmark disability will be adjusted against the SC point in the reservation roster, and the unreserved candidate with benchmark disability against the unreserved point in the relevant roster. In case none of the vacancies fall on point reserved for so-and-so, the candidate candidate under benchmark disability belonging to SC shall be adjusted in the future against the next available vacancy reserved for SC. So, my lord, that is the modality you have to fill up. It has got nothing, because this reservation is not predetermined, my lord, that we will give SC 3 PWD or ST 3 PWD. It's not predetermined. It's determined after
Now the point is,
this post, my lord.
How are you affected by the?
Because, my lord, the interim order is there that 1 post reserved meant for PWD is to be stayed.
If the stay order is removed, then what?
Then I get that appointment, my lord. And my lord will make it subject to the outcome of the case. That's all, my lord. Because I prima facie have a case, my lord, on that. But my lord will finally decide that matter. In the meantime, my lord, why, my lord, keep me out?
No, why should he get it now? Because prima facie, lordship will find prima facie, out of that post, admittedly, 2 PWD candidate cannot be accommodated in SC category. Only one. Only one gets it. One PWD candidate can be accommodated against the SC reserve, SC post. That is, number of SC post is 12. 4%
We
reserve.
have to hear the matter first.
Exactly. And that is how this
To
other.
the date, please, to the.
Yes,
date.
well, it needs a hearing and on 3-4 occasions it was taken up.
My lord. No, no.
Three persons were kept out of the appointment now.
And my lord, I'll only take one page. I'll take my lord's attention to one page, and then my lord, that will answer my senior's query. Then I'll pray for the vacation, my lord.
Here, Lordship will find this honorable court directed the government to place all the records. On 2-3 occasions, this order was repeated. Lordship will kindly see ultimately. When this interim order, by this initial interim order, 2 posts were kept vacant, reserved, not to be filled up.
Three posts.
Then it relates to the women category also. Subsequently, petition was filed for vacating. The honorable court took up the matter and vacated the order, keeping only 1 post reserved. That is the PWD, because it appears that there was overlapping of layers of reservation. And therefore, direction was given. Lordship will find at page 107 of the IA, their IA, 9798. This was the order by which ultimately that interim order was modified and my learned friend appeared for another petitioner there. Lordship got it, my lord. 107. So paragraph 3, Lordship will come. As the issue also involves in what manner the provisions of section 33 and 34 of the Rights of Persons with Disabilities Act 2016 had been implemented, we have also requested the presence of Mr. D. Nath, learned senior government advocate, to assist the court in providing the information as to in what manner the state government has implemented the aforesaid provisions, and the records of such implementation may also be produced. We are clarifying that by the expression implementation as to in what manner in every establishment the appropriate government has identified the post which would be suitable for persons with a disability, and further persons with which category of disability. As our interim order dated 24/6/2022, a restraint order had also been passed to keep 1 post reserved for SC women to be not filled up. And as after hearing the matter at some length, it appears that no claim has been made by any of the parties for the post vacant, which is earmarked for SC women. And the respondent number 6 is already a selected women candidate in the SC reserve category. We modify the interim order to such extent that the earlier direction is also not fill up 1 post reserved for women reservation for SC category shall now stand vacated, but while retaining the other provisions of the interim order. The respondents may act accordingly. The respondents to also provide the information to the court as to what is the total number of disabled persons already employed in the individual establishments under the government of Assam, and whether such number of exceeds 4% of the number of posts available for such establishment. So these informations are very essential. They cannot overlap.
Matter will require some.
My lord, it will require some
hearing.
But my lord will only note the prayer of my senior is that the person cannot be adjusted against an SC vacant post.
Yes.
My lord, only 2 pages I'll take, my lord. First, in the IA, my lord comes to page 83.
27th of July.
7th.
27th of July.
Man, boy is hanging, my lord, a little bit earlier, if possible.
26th.
That was classic.
Because on very many occasions the matter came up, but could not be decided because of the information asked for had not come before the court.
That information,
is even now today it has not come.
for
let
the
them come
prayer
up.
and the writ petition.
I want that this should be decided because I am also hanging. If I'm entitled,
My lord,
I must get it. If not, I must get a message that, no, I am out. Therefore, my lord, it is in the interest of the things that both all of us, that it should be heard and decided early. I'm insisting for earlier hearing, but not coming.
All right, heard Mr. Yukin, senior counsel appearing for the applicant. We have also, I have also heard Mr. K.K. Monto, senior counsel appearing for the writ petitioners opposite parties.
Oh, yeah,
Mr.
not
T.
from me.
Nayak, and a
Enough.
standing, you are appearing as standing counsel.
Lordship,
Which is the party?
PNRD.
Mr. T,
Earlier, in the earlier interim order, 3 persons were kept out of the, they were barred not to appoint lordship. Out of those 3 lordship, 1 person has already been allowed to give appointment lordship. She has been appointed. Now 2 persons are awaiting lordship. 1 person, he has joined another department lordship, so he is not coming. Now this person is before your lordship.
PNRD is present. After hearing the arguments of learned counsel for both the sides, this court is of the opinion that deciding the IA would require this court to enter into the merit of the case projected in the writ petition. Stop. Therefore, instead of taking up the IA, the proper recourse would be to take up the writ petition itself for disposal. Full stop. In view of the above, and as per convenience of learned counsel for all the sides, the writ petition is directed to be listed as a fixed item on 20. You want it 27 or
27 would be fine, it's just Thursday.
my lord,
Thursday.
my apprehension is those days will be only on motion days because just before vacation.
No, after vacation.
After vacation.
After vacation.
July, okay.
July.
Yes, then okay.
27th of July 2023 as fixed item.
The state government was
Along
only.
along with this IA, this matter will be taken up for final disposal on the next date fixed. The learned counsel for all the parties, including the learned government advocate Assam, to come prepared accordingly.
Lordship.
Which we model passed earlier to continue.
Mr. Nath's name may be reflected in the causes, D. Nath, in your
These
government.
matters be listed again, reflecting the name of Mr. D. Nath, and a senior government advocate Assam in the court list. You are also appearing. So Mr. P.P.
Aye.
counsel has appeared for the appeals.
Obliged.
Order implement of Article 59.
Into the July, it is on the plan, within the parties, where they have said that post is vacant. But after hearing the matter, both said that the parties may be equally referred to.
Yes, but
We have seen that.
Oh, yes.
posts are vacant.
My lord, here, we have paid for implement of the new respondents
So been appointed meanwhile.
who have been meanwhile appointed.
They can say that 7 posts are already vacant, they are not joined.
My lord, our claim was that
Higher on merit.
we stand higher on merit in the list,
They reduce category.
but we have been denied on some flimsy ground, and therefore we challenge it. Meanwhile, the other persons have been allowed, those who were lower in grade, lower in rank to us, they have been appointed. And during the course of hearing, this honorable court also found that maybe some candidates may be affected if ultimately order is good. Although 7 posts are still lying
all
vacant.
right,
but
heard Mr. K.K. Mohanty, senior counsel listed by Mr. K. Mohanty, counsel for the applicant. Also heard Mr. P.P. Dr. Lani standing counsel. APSC appearing for respond numbers.
P4 and 5.
P4 and 5, upper due Mr. C.S. Harrington and government advocate association for respond numbers 1, 2, and 6. This IA has been filed with a prayer to include the selected candidates as respondents in the connected writ petition. The names and particulars of the selected candidates have been furnished in paragraph 4.
At page 6, paragraph 4.
Paragraph 4 of the application. Since it is the case of the writ petitioners that despite having fared better than the selected candidates in the merit list, they have not been appointed, and instead the aforesaid selected candidates have been issued order of appointment. If the petitioners succeed in their prayer, then it may disturb the appointment orders issued in favor, it may disturb the appointments of the private respondents. As such, the selected candidates are necessary parties to this proceeding. The Respondents' Council have also not opposed the prayer for imprisonment. In view of the upper, the prayer made in the highest stands allowed. The selected candidates named in para 4 of the application be included as respondent number 7 to 29.
Yes.
7 to 29.
Yes, sir.
In the connected writ petition, registry to carry out necessary correction stroke endorsement in the cause title of the writ petition. And list the matter thereafter for necessary orders. Highest and disposed.
And that should be 7 to 22. From 7 to 22, there are
7 to 22. How many are there?
22. 22 are there.
Total 22. 22 cannot be 7 to 22.
No, Malad, there is already up to 6. Then 7.
So if you add another 22 with 6, it is 7 to 28.
That I will sit with, they will sit with.
Yes. How many persons are to be implemented?
Here, as it appears from 1 to 22, no? Yeah. 22 persons.
So how can 22 persons be 1 to 26 to 22?
7 to 20.
7 to 28.
7 to 28.
7 to
Right,
28.
Yes,
Right.
yes, next matter.
Yes.
7 to 28.
Notices may go to them.
No, let the writ petition be listed then.
I see.
Has his representation been considered and disposed of?
Malad.
Huh? Yes. Has it
Malad,
been done? Serious problem, low back pain. What to do? He cannot go into.
The first, he was submitted prior to issuance of the impending order. He has submitted a representation. On basis of that, Yellow says yesterday his name is there, not acceded to. His request for deferment and cancellation was not acceded to, and in fact, my lord, he has completed the statutory period of 3 years. He has more than 4 years, 1 month.
All right.
And he was directed to be join the Nazira. They are well equipped medical facilities are there.
We'll grant him 1 month's time to go. Heard
Hello.
Mr. D. Bora, learned counsel appearing for the petitioner. Also heard Mr. U.K. Goswami, learned CBC appearing for the respondents. The petitioner has approached this court assailing the transfer order dated 3/5/2023, qua the writ petitioner, transferring him. Now you write before that. The petitioner is presently posted as CT/GD in the CISF unit,
OPS number.
OPS Nunmati at Guwahati. Stop. Assigning the transfer order number 06/2023 dated 3/5/2023 issued qua the petitioner, transferring and posting him at the CISF unit at ONGC, Nazira. The present writ petition has been filed. The grounds for challenge of the transfer order are as follows. First up, the petitioner is suffering from low back pain, bracket lumbar disc, BULGS, bracket close, and is undergoing treatment at Guwahati. Moreover, the wife of the petitioner has given birth to a male child about 4 months back, and hence he is required to stay at Guwahati. First up. Mr. Goswami submits that there is proper medical facility at the ONGC campus at Nazira, where the petitioner can avail treatment for his disease. Moreover, the ground that the petitioner's wife has given birth to a child cannot be accepted to interfere with the transfer order. Mr. Goswami has also produced a copy of the communication dated 29/5/2023, which goes to show that the representation submitted by the petitioner has been rejected by the authorities. Full stop. After going through the materials available on record and upon taking note of the statements made in the writ petition, this court is also opinion that the two grounds stated by the petitioner, namely his suffering from low back pain and being the father of a newborn child, cannot be a ground to interfere with the transfer order. Moreover, it also appears that the petitioner was posted at Nunmati on 17/4/2019, and he has already completed more than 4 years in the same place of posting. As such, as per the policy guidelines, as per the policy guideline of transfer of CISF personnel, the petitioner is due for transfer. Full stop. In view of the above, it cannot also be said that the impugned transfer order has been issued in violation of the policy guidelines or the condition of service of the petitioner. Full stop. Situated thus, I do not find any good ground to interfere with the transfer order of the petitioner. The writ petition is therefore held to be devoid of any merit, and the same is accordingly dismissed. However, having regard to the facts and circumstances of the case and the request made by Mr. Bora, the petitioner be granted 1 month's time with effect from today to join in a new place of posting. A copy of the written communication dated 29/5/2023 will remain in the record. Writ petition stands disposal.
Bless.
For admission, I can take it.
Lordship, that in that case, I will file our affidavit in reply.
Mr. H. Bajpura prays for and is granted 4 weeks time to file rejoinder affidavit. Mr. S.S. Roy, learned CGC, is present on behalf of the respondent. This is the matter at hand. None appears for the petitioner on call. Mr. S.S. Roy, learned CGC, is present.
Government.
Government Advocate Assam is present on behalf of the state. Since the petitioner's counsel is absent today, this matter will be listed again after the upcoming summer vacation.
Obliged.
Last order may kindly be seen. Affidavit has been filed. No, affidavit has not been filed by the finance, but I'll place the matter under the, I'll leave it to you. 1984, the petitioner was appointed as a work charge employee, Khalasi minor. Subsequently, in the year 2019-99, he was promoted. Here, page 19, your lordship, page 19. He was in the year 1984. 1 minute.
Sorry, I think that I'm.
What?
So on last date, I prayed for filing my affidavit, Lordship. It is already there. Today morning, when I talked to them, they said 3 days time will require because they are under heavy work pressure. That is what their explanation, Lord.
Last order is there, my lord.
It is there, Lord. The only reason.
Mr. B.D. Das, senior counsel, has appeared for the petitioner and pointed out the order dated 16/5/2023 to submit that despite the leave granted by the court, no affidavit has been filed by the department till today. First of Mr. Nayak, learned standing counsel, Finance Department, Assam, submits that the affidavit is ready and shall be positively brought on record on or before 5/6/2023 by serving advance copy upon the petitioner's counsel. In view of the above and on the request and on the assurance of Mr. Nayak that no further prayer seeking time for filing affidavit will be made in this case, this matter is directed to be listed again on 7th of June 2023.
Obliged, Lord. Obliged.
Item 29.
Now, pleadings are exchanged otherwise in this matter. There are 2 identical repetitions, my lord, in this matter. May I pray, my lord, all this three can be tagged and posted sometime in July, my lord.
All right. Mr. B. Pathak, learned counsel for the petitioner is present and submits that this matter is ready as regards pleading and can be taken up for disposal at the stage of admission hearing, along with WPC number
1130 of 22
1130 of 2022
and 2573 of 23.
and 2573 of 2022, which are analogous. Mr. P.S. Bhattacharya, learned CGC, is present on where the respondents and does not have any objection if the prayer is done. In view of the above, registry to list this petition along with the connected matters on a non-miscellaneous day in the fourth week of July 2023 as a fixed item. As fixed items.
Lordship, here I seek for 2 weeks further time to file an additional affidavit. Lordship, I have received some instruction.
Yes, heard Mr. Sharma, heard counsel for the petitioner, Mr. D. Upamanu, learned SC has submitted that he has received some instructions and therefore be permitted 2 weeks time to file an additional affidavit. Prayer allowed, let the matter be listed again after 3 weeks.
Lordship, may I pray for a date? Also? May I pray for a fixed date? Also?
All right, then. Till we are up, let the matter be listed again on 26th of June.
March of license.
2023.
May please, the lordship was in your left in October 17, my lord. So it may be taken at 2, my lord.
Lordship, I am appearing for respondent number 5 and I need to file the affidavit, counter affidavit.
All right,
And
Mr.
so far, Lordship, they have filed appeal also under the provision of the executive instruction, and that appeal is pending, yet to be decided, but they have approached here before this honorable court. Lordship,
Then
we
let
find
the
it
appeal
is
be
for-
decided.
Yes, yes.
Appeal be decided in a time bound manner.
Yes.
Heard Mr. F.A. Hasan, learned counsel for the petitioner, also heard Mr. H. Chakravarti, Mr. S. Datta, learned SC Revenue, as well as appearing for respondent numbers 1 and 3 and Mr. H. Chakravarti.
4
and 4 also.
I'm for 5.
Mr. D. Vora, learned counsel and appeared for respondent number 5. By filing this petition,
Has not yet been
challenge
passed.
has been made to the selection of respondent number 5 for appointment in the post of Gao Pradhan of Shampupara Gao in the district of Kamrup. Mr. Bora submits that the petitioner has already preferred an appeal under Rule 162 brackets 2 of the executive instructions framed under the Assam Land and Revenue Regulation 1886, which is pending disposal. Therefore, full stop. Therefore, this petition be disposed of by directing the concerned divisional commissioner to dispose of the appeal in a time bound manner.
Lordship, appeal has not, appeal has been withdrawn here.
But in the read petition, it is written. not yet.
Withdrawn here.
Then we'll close this matter.
Earlier it has been withdrawn.
File an appeal then.
Hmm.
Mr. Bora submit that part is cancelled. Submit that the order and that the selection of the respondent number 5. And then you write Mr. S. Datta, not Bora. Mr. S. Datta, learned SC, Revenue submits that the selection of the respondent number 5 is appealable before the jurisdictional divisional commissioner in an appeal preferred under Rule 162 C of the so and so, and therefore the petitioner be directed to prefer an appeal. Full stop. Mr. Chakravarti, learned government advocate Assam, also submits that in similar matters, this court has passed orders delegating the parties before the appellate authority. Full stop. It appears that the petitioner had earlier preferred an appeal, but the same had been withdrawn before approaching this court. Be that as it may, since there is a provision to prefer an appeal, and considering the fact that the allegations made against the selected candidate would require require inquiry in the domain of, would require factual inquiry Hence, as agreed to by learned counsel for both the sides, this writ petition is being disposed of by providing that the petitioner may prefer an appeal before the jurisdictional divisional commissioner. First of, if such an appeal is preferred within 2 weeks from today by enclosing a certified copy of this order, the same be considered and disposed of by a reasoned order within this statutory period. Hard on the prayer of interim relief, having regard to the facts and circumstances of the case, it is hereby provided that no order of appointment shall be issued in favor of respondent number 5, if not already done, without verifying the allegations brought by the writ petitioner. First of,
I'm sorry, I was on late, but no appointment shall be made till the disposal of the appeal.
Mr. S.C. Viswasanam, without verification, no appointment.
Already 60 days have been elapsed. They have to file appeal along with a delay condolence.
Limitation.
Along with the application for condonation.
Plus.
File an appeal along with, if an appeal along with condonation of delay is filed within 2 weeks.
Lordship, I am appearing for respondent number 8 here, private respondent. The here also issue is same, your lordship. They ought to have approached before that divisional commissioner by filing an appeal, your lordship, under that provision. That has not been done. Alternative remedy was there.
In this case, my lord, already inquiry has been done. And the respondent authorities, I am challenging the eligibility of the respondent number 5, respondent 8, my lord. And the respondent authorities inquired the matter, my lord, and annexing the 2 inquiry report, my lord, they have submitted the affidavit, my lord, supporting his candidature, my lord. So the prime ground in here, my lord, in this case, my lord, the post of the Gambura has been felt vacant due to retirement of the petitioner's father, my lord. And to fill up that post, my lord, along with other posts, my lord, an advertisement was issued. In the advertisement, my lord, under the eligibility criteria, it is provided that the person shall not be a member of any political party, my lord. And thereafter, my lord, the person should be a resident of the area.
Inquiry is one thing, appeal is another thing. Appeal is a statutory remedy. Appeal and inquiry, that inquiry may be made by anybody. But once an appeal is filed,
yes,
that appeal has to be decided and then.
I have not filed, my lord.
Why?
I have not.
Why you have not
Because the appeal, my lord, the appeal should be filed from the date of appointment, my lord. Here I have approached this honorable court, my lord, before appointment, my lord.
No, there is division bench judgment.
My lord, in the,
Give it to him, he doesn't know.
my lord, in the division bench judgment, my lord, it is the clear finding that the appointment has been made, my lord. Therefore, in that facts and circumstances, my lord, division held that he should prefer the appeal, my lord.
Let me see. Let's see the judgment.
And so far,
You have filed affidavit.
I have replied, your lordship, and so far his contention in the writ petition, basically, he is not the resident of that locality and he is a member of political party. I have annexed here the documents, your lordship, in my reply. So it pays
Selection also appeal is, that's
Yes.
what.
My lord, in the case, my lord, in the judgment, my lord, page 7, my lord, can you see that the scheme of the executive instruction and the materials available on record clearly postulates that the respondent authority gave an advertisement for filling up the post of Gampadan, and after conducting viewers in the respondent number has been appointed as Gampadan. My lord, here, my lord, I have also annexed the appointment.
Oh, the order says selection and appointment are interchangeable. Appeal will lie both against appointment and selection. Why don't you read that part? That part you are skipping. But I heard Mr. S. Learned Counsel for the petitioner, also heard Mr. S. Datta Learned Standing Counsel, Revenue Department, Assam, appearing for respondent numbers. Respondent number 1, Ms. M.D. Bora Learned, Government Advocate, Assam, for respondent numbers
2 to 6.
2 to 6, and Mr. D. Bora Learned
for 8.
Counsel appearing for respondent number 8. It is submitted at the bar that this matter is ready as regards pleadings and can be taken up at this stage of disposal. At this stage of can be taken up for disposal at the stage of admission hearing. In view of the above, registered list this matter for admission hearing, for disposal, in the column of disposal at the stage of admission hearing, again on 22nd of June.
May I please, in this case, and the respondent has supposed to file a affidavit, but no affidavit is filed. So the private respondent also appear also.
Lordship, I'm appearing for the private respondent number 8 to 11. Lordship, we may be allowed 2 weeks time to file our affidavit.
Mr. A. Chetri, our counsel is present on behalf of the petitioner. Mr. Yanim
K. Bushra,
K. Bushra, our counsel appearing for respondent numbers 8 to 11,
7 to 10.
7 to 10. Raise
I am
for
for 1 to 6.
2 weeks further time to file affidavit. Prior affidavit, first of Mr. Kalita, K. Kalita, learned counsel for the
Respondent 1 to 6.
respondent number 1 to 6 is also present. In view of the prayer made at the bar, this matter stands adjourned for 3 weeks. So as to allow the private respondents to file affidavit.
May I please? My lord, I want to file a reply against the affidavit notion filed by respondent number 8, my lord.
Mr. B. Rahman prays for and is granted 3 weeks time to file reply
Okay,
affidavit.
Hundred may be given, lordship. They have found sufficient
Responding
time.
to the affidavit filed by the respondent number 8, Mr. S. Dutta, learned SC Revenue Department, Assam.
Respondent number 3.
Present for respondent number 3 and Mr. S. S. Roy, learned Government Advocate, Assam for respondent numbers
1, 2, 4, 5, 6, and 7.
1 to 4, 5, 6, and 7.
May I please?
Let the matter be listed again after 2 weeks as a fixed item.
May I please? Lord?
Well, interim order is the apply. Interim order is the apply continue.
Interim order passed earlier to continue till the next listing.
In this case, Lordship, I am representing respondent number 3, Lordship. In my affidavit, in affidavit written as respondent number 1. I may be permitted to.
No, whatever is there, let it be there.
Lordship. Okay.
This matter pertains to appointment of arbitrator.
Lordship, I have received the instructions. Lordship will permit me 2 weeks time. I will file my.
All right, heard Mr. B. Bora, learned counsel appearing for the petitioner. Also heard Mr. R.K. D. Chaudhary, learned DSGI appearing for the respondents who submits that he has received instruction and therefore be permitted 2 weeks time to file affidavit. Prayer allowed. Let this matter be listed again after 4 weeks.
It's a date may be fixed also.
Date it will come. 3 weeks. 3 weeks. Yes.
May I please, your lordship?
Yes.
Lord, the petitioner before your lordship is agreed by the incorporation of the name of the respondent number 5, my lord, in the select listment, which is at annexure 2, my lord. Page 23, my lord. On the grounded, my lord, she is not the resident of the survey area within that Anganwadi center, my lord. But the respondents have filed their affidavit, my lord. Although they have mentioned that her name appears in the register, my lord, they have only annexed the document, my lord. That is at page.
You don't want to file any rejoinder.
We'll file, my lord.
How much time you want?
1 week time.
All right. Mr. D. Kolita, learned counsel for the petitioner prays for and is granted 10 days time to file rejoinder in response to the counter affidavit filed by the respondent number.
Well, respondent number 4.
Respondent number 4. Mr. C.S. Hazarika, learned Government Advocate Assam is present on behalf of respondent number
1 to 4.
1 to 4 and
I am 5.
A. Mondal for Mr. A. Mondal for respondent number 5. Let the matter be listed after 2 weeks.
Obligement.
This is the last order.
In this inspection was sought for lordship.
Lordship, I have received one communication. They take some more time, Lordship.
How much time you want?
10 days, my lord.
Lordship, my interim may be considered lordship, best 12 lordship.
What is the interim?
Lordship, select list may not be cancelled lordship during pendency of the case. Yes, 12 plus.
My lord may fix the matter next week. I will give the instruction, my lord.
That order cannot be passed.
My lord, 2019
No,
select.
that kind of order cannot be passed. We have
My
to
lord.
see if there is a good ground, then they will cancel. Why not? Heard Mr. So-and-so, our counsel for the petitioner, also heard Ms. M.D. Bora, who has produced a copy of the written request issued from the departmental authorities to seek 2 weeks further time to obtain instruction. Mr. S. Daktal and SC Revenue is present on behalf of the department. In view of the request made by the learned government advocate, Assam, this matter stands adjourned for 2 weeks.
My lord.
Date
And
may be
if
fixed, sir. Date may be fixed, sir.
It will come after 2 weeks. So,
Remember
where is
to-
the order?
3 numbers of director has been indicated. First was Anjan Sharma, second was Povitra Khan, and third is Dharmakanta Milik. Grievance is only one part is complied. My service has been reinstated, but area salary has not been released.
I was simply the lordship by order dated 19 to 2020 lordship.
Yes, 19 to 2020.
You file a fresh writ petition for area salary. There is no direction to pay area salary. You are getting a regular salary.
Yeah, now I am getting.
So the order is to pay salary, not area salary.
Pay salary and reinstatement.
Area salary, my lord, since 2005.
Where is the expression area in the order?
2005 to.
All right,
Yes,
heard
my-
Mr.
my lord.
The Islam learned counsel for the petitioner. Also heard Mr. K. Gogoi, learned counsel appearing for the respondents. This contempt case has been filed alleging willful disobedience of the order dated 16/9/2014 asked by the learned single judge in WPC number 1186/2014. First up, Mr. Islam submits that in terms of the directions contained in order dated 16/9/2014, the petitioner has been reinstated back in service and is presently receiving his regular salary. First of, however, the arrear salary has not been paid to the petitioner. On a close reading of the order dated 16/9/2014, this court finds that there is no direction to pay the arrear salary in the order dated 16/9/2014. First of, in view of the above, this contempt case is hereby closed by granting liberty to the petitioner to file appropriate proceeding for payment of arrear salary, if so advised.
My lord, in the page number 10, my lord, in the last line, it is said that till reinstatement shall be regularized and the petitioner shall be paid his salary.
Salary,
My
yes,
lord.
not arrear salary.
This level.
Yes.
The order is page number 8, my lord.
But here it's regarding, my lord, considering the case of the petitioner for compassionate appointment. My lord, I have instruction to say that, my lord, in 2010 itself, my lord, her case was considered and it was rejected by the DLC.
Order has two parts, my lord, either completion appointment or my lord regularization. Page number 9 is
To
the relevant.
consider.
Compulsory appointment or regularization?
No, sir.
What kind of a prayer is this?
My lord,
Page
number
9.
9, my lord.
Petitioner is still working
My lord.
on
Fixed
a
pay.
contractual basis.
Contractual basis, my lord.
Well, liberty may be given to the petitioner to challenge it, my lord, if she desires.
No, what about regularization? She is working since 2007.
Regularization, my lord.
That, of course, my lord, the speaking order will have to be passed in that case.
But it has not been passed. So what to do? This is the clear case of
One part,
contempt.
it has been already complied,
But what about the contempt? Who is supposed to pass?
lordship.
Who is supposed to pass that order?
The commissioner will have to pass, my lord. The present one, my lord.
What option are you leaving us then to call him?
That's the difficulty, my lord. They used to, my lord, get transferred or retired very soon. By the time, my lord, something can be done, the person, my lord, gets either retired or he moves to another department. This has happened in another 2-3 cases, my lord, listed today. If he
So what
impeach,
to
my
do?
lord,
You want to file a fresh writ petition on this prayer, or do you want?
Let them consider, my lord, regarding.
No, in a contempt case, we can't say all these
Yes,
things. You have to either implead him.
My lord, let them get the instruction regarding regularization part.
No, the person to pass the order is not a party here.
We will implement, my lord. I will have.
All right. But I think you should better file a fresh writ
Yeah.
petition and get your claim ascertained. This order, they will reject your prayer. What else will they do?
at least he can get the minimum of the pay scale, my lord, as per when the if she files
Better
it.
file a fresh writ petition and get a positive direction. Compassionate appointment not possible.
Competition already.
2005
Regarding the regulation.
application cannot be considered. So we'll give you liberty to file a writ petition to assert your right to be regularized. Get an order to regularize, not consider. Consideration, they will not do it. Heard Mr. Aero, learned counsel for the petitioner, also heard Mr. B. Gogoi, learned counsel appearing for the respond numbers.
My lord, 1, 2, and 3.
Respond numbers 1, 2, and 3, who submits that these clients have already been transferred from the previous posts, and therefore they are no longer responsible for implementation of the court's order. I find that by the order dated 5/3/2014, passed by the learned single judge in WPC number 1204 of the 2014, direction was issued either to consider the case of the petitioner for appointment on compassionate ground, or to consider her case for regularization in service based on her contractual engagement made on 02/11/2007. Insofar as the direction to consider the case of the petitioner for appointment on compassionate ground, Mr. Gogoi submits that her aforesaid prayer has already been rejected by the DLC. Full stop. However, insofar as the direction to consider the case of the petitioner for regularization in service is concerned, there is no such direction, and there is no such consideration made till today. Full stop. It is apparent from the materials on record that the petitioner has been serving continuously since 2/11/2007 against grade 4 post on contractual basis. Therefore, even divorce the order dated 5/3/2014, the petitioner may have a right to be regularized in service in the meantime. A petitioner may have accrued a right to be regularized in service due to her long and uninterrupted continuance in service. No such direction, however, can be issued in a contempt case. Therefore, by granting liberty to the petitioner to approach this court by filing appropriate writ petition, seeking a writ of mandamus upon the respondents to regularize her services, this contempt case stands closed. You file a petition and ask for a straight direction. No longer this consideration business. You succeed, the court has to determine that you are entitled to regularization. Otherwise, they'll reject it. This is no good.
Presently, we were concerned with the enhancement of the salary of the members as well as the staff of the existing ordinance tribunals. Last two occasions, that is 22nd February 2023 and 29th 2023, your lordship's pass order granting them time to obtain instructions regarding the developments. Central government as well as the state government.
What are the developments?
My lord, so far as the state is concerned, my lord, this is the response lordship may kind of, we have already sent the proposal to them to consider their case sympathetically because this is too less. So they are unable to run their families. So intimated to the center. এটা দেখিছো তোমালোকৰ ৰিপ্ৰেজেন্টেটিভ পঠাইছো তোমালোকৰ ইহঁতৰ ৰিপ্ৰেজেন্টেশনটো প্লাছ আমাৰ ফালৰ পৰা ৰিকুৱেষ্ট ইহঁতক দিব লাগিব এইটো কি বস্তু
So where is the CGC, DSGI? Where is Mr. Dev Chaudhary?
নাম দেখো না নেই পজিশন নাম দেখো না
So what is this?
Look, this is with regard to some security arrangement is to be made. Milord, my senior, if I have given a copy to him also, Milord. If the state can take care of this, Milord, there will not be much problem. But this thing has come to light.
So this communication has been sent to the MHA when? Mr. Majumdar,
my lord
his letter, the instruction of 24th May, fixed pay to scale pay. This is regarding members of Foreigners Tribunal.
no man
Then,
staff lordship kindly see.
but they are asking for conversion of members.
No staff I think
Members as well as staff, both.
I think it has gone for both I think next page is the actual letter we have written
Look on
to the
representation.
central government man. Their representative itself was sent.
But it seems it has been only referred to for employees, not the members.
So far as member is concerned, already this honorable court Milord,
members
constituted a
possibly,
committee and that committee recommended, Milord, the enhanced pay of the members.
Recommended to whom?
Recommended to the government.
Then
That remain unimplemented, Milord.
that's
That
what
has
I'm
to-
asking.
Yes, man.
Ultimately, according to them, the union government has to do it.
Yes.
So where is the recommendation to union government, Ministry of Home Affairs to consider the case of Foreigners Tribunal members?
अपनी जो member असेल ना, उसी chairman असेल आपण. तो आपली मत आहे ना, member.
Well, so far as the members are concerned, possibly I'll have to find out. I think already it has been written earlier. It is only in respect of staff probably. I'll just find out, madam. Possibly it has already gone because the committee gave a report quite I think a year ago.
The committee was,
Mr. Dev Chaudhary, it seems communication was issued, are you aware? On 23rd February to the MHA for a conversion of fixed pay to scale pay.
Lordship, I have received a letter last week, Lordship. Some clarifications were required to be given by the state government, which has now been given. Lordship.
Yes, but this is only regard to staff or the members.
It was regarding the members, Lordship.
Are you sure?
Yes, Lordship.
Do you have the communication?
Lordship, I have it in my mail.
Possibly about for the members, recommendation went earlier for this case. And this is, I think they are yet to take a call on this about the staff.
Lordship, I don't know. I guess.
Take down our Mr. H.K. Das, Learned Council, Learned MHSKV, as well as Mr. A. Das, H.K. Das and Mr. A. Das, Learned MHSKV appearing. In this case, also heard Mr. D. Majumdar, Learned Additional AG Assam, appearing for the state, who submits that proposals have already been sent to the Ministry of Home Affairs, Government of India, for conversion of the payroll of the members of the Foreigners Tribunal as well as the supporting staff from fixed pay to scale pay. But the matter is pending before the Union Home Ministry, full stop. Mr. R.K.T. Chaudhary, Learned DSGI, submits that very recently he has received the communication from the MHA, which indicated that some clarifications have been sought from the government of Assam to process the aforesaid recommendation. Therefore, another 4 weeks' time has been prayed for so as to obtain updated instruction and place the same before the court. Mr. R.A. Tapadar, Learned Judicial Registered Judicial is present, is personally present before this court, taking note of the request made by the Learned CGC. Learned DSGI, this matter is directed to be listed again on 30th of June 2023. In the meantime, the issue pertaining to the security issue raised with regard to the Foreigners Tribunal at Balipara, is it?
Balipara.
Balipara.
FT7.
A Foreigners Tribunal being FT number 7 at Balipara, be looked into by the state government, and remedial measure, if any, be initiated in respect thereto. Yes. You have a copy of this, Mr. Murali?
Just now they have given.
Yes. We are.
See what is there. It's not something very big, but the matter needs to be looked into. Yes, yes, next matter.
Highly.
May I request your lordship, this issue, if the SP is the person who will take care of this matter, if his security, lordship may straightway direct, so that again a letter from our side, then SP getting the letter, not
No,
knowing.
we'll not. The direction is to the Home Ministry. You do your job. Why should the court direct the SP? The court has already said the Home Ministry to look into the matter. You issue instruction to the SP. Yes.
May please, also. This is the contempt manual for non-compliance of the order dated 2/11/2017. That is page number 8.
I am the respondent of as per telephonic instruction I have received today, that order has been complied with, but documents I don't have with me. So lordship may given some time that they may be, they also may inquire about from the petitioner. Otherwise, I have instruction that telephone order has been complied with, lordship.
Let them bring the written instruction.
Sometime maybe given also I'll obtain written instruction. Pension to paise. Pension paise.
Mr. A. Boro, Learned Counsel, is present on behalf of the writ petitioner, Ms.
S. Khonikor, for
S.
respondent number 1.
Learned Counsel appearing for the respondent number 1 submits that the order of this court has already been complied with, and the pensionary dues have already been released in favor of the legal heir of the deceased employee. Mr. Borough, however, submits that he does not have any instruction to that effect. In view of the above, this matter stands adjourned for 2 weeks so as to enable learned counsel for both the parties to obtain updated instruction. List accordingly.
Diplo, please.
Yes, who is appearing?
MHA and other his colleagues are there, Lordship. Today it is listed that they had taken substituted service and affidavit they had filed regarding substituted service, Lordship. None is there.
But the affidavit is on record,
Yes, Lordship,
but they are not present.
not present.
None appears for the writ petitioner when the matter is called up. Ms. B. Sharma, learned CGC is present on behalf of respondent.
1, 2, 3, and 7.
1, 2, 3, and 7. It appears that after taking steps for the service of notice of this case upon the respondent numbers 4, 5, and 6 by substituted method, that is newspaper publication, an affidavit has been filed by the petitioner, and the same is also on record. However, since the petitioner's counsel is absent today, this matter stands adjourned for 2 weeks.
Obliged.
May it please the Lordship. There is a direction for personal appearance of the respondent number 2. He is present now.
Who is the respondent number 2?
He is the superintending engineer, my lord, retired of my lord, Tezpur.
Why direction of personal appearance was given?
On that day, my lord, when the matter was called
None
up.
appeared, my lord. On
Yes.
that day.
I'm sorry.
We
On
were
that
on
day, my lord,
lakes,
none had
we were on lakes in another court, my lord, so the order was passed. But here, my lord, the fact is.
1 minute, 1 minute.
Ah, there is a- The order is given now by the-
Order 2.
No complaint to the- 9, 10.
What is the direction? Where is the order?
Order
Page
is
number
at
9,
page
my
10, my lord. Relevant portion, my lord.
So Lordship will kindly see, my lord, page 9 for a moment, my lord.
Hmm.
Right from the government to the executive engineer, all were party respondent in the main writ petition.
Hmm.
Here only the superintendent has been made party respondent in the contempt petition. But he is not the authority, my lord, who will move the proposal. He is not the authority who will sanction it, my lord. Even he cannot forward it to the, my lord, government. It is the executive engineer who will have to move the proposal. He will send it to the chief engineer. Chief engineer will, my lord, forward it to the government in the PWD department. And if there is paucity of fund, they will have to move the finance department. Only the, my lord, superintending engineer has been made, my lord, party respondent in the present contempt petition. And by now, my lord, 50% of the amount has already been paid. And direction was to, my lord, make the payment as per termserally, that chronological list. So, my lord, time to time, part payment has been made. And my lord, in the meantime, proposals have been submitted to the civil engineer for granting the balance amounts.
No, personal appearance was directed because in a contempt case, you cannot let it
No,
go.
on that, on merit, I am saying, my lord. In fact,
Every
my lord,
time
this-
there is no representation, we will direct
Yes, sir.
personal appearance.
No, that I am not saying, my lord.
Contempt case
Yes.
is contempt case.
No, he other that he has nothing to say on that
So-
point, my lord. And my lord, he has
What
retired-
action he has taken to comply with the
my
court
lord,
order?
today he has completed 1 year of his retirement. Exactly 31st May 2022, he retired. So in between, he has got some document to show that the executive engineer has been submitting proposal.
Where are those documents?
My lord, that he has brought it, my lord, from the office, my lord, because he has no access to those records. Even then.
That's all right.
Yes.
These things should have been pointed out to the
My
court.
lord.
Nobody was there to point out.
I'm sorry for that. But my lord, perhaps my lord, the petitioner will have to include the executive engineer, my lord, and the civil engineer in the present contempt petition. My lord. Earlier also such proposals were mooted. And this is the latest one. Party no. Civil engineer particular, executive engineer particular. No, no. It's complete one. And my lord, specifically, he has been implicated. Otherwise, my lord, in order to, my lord, for an effective.
And what about the
compliance-
respondent number 1?
He has retired, my lord.
One, he has retired, so he was implicated.
All right, take down. Heard Mr.
As Upadhyay.
S. Upadhyay, learned counsel for the petitioner, also heard Mr. B. Gogoi, who is present on behalf of the respondents. In terms of the order dated 28/4/2023. The respondent number 2, that is Sri Kamakhya Prasad Das, is personally present before this court. Mr. Gogoi submits that although the respondent number 2 has retired more than a year back, yet in terms of the order of this court, he has appeared personally and is presenting documents to show that the petitioner did not have any role in compliance of the courts, or in the respondent number 2 did not have any role in compliance of the court's order. As a matter of fact, necessary records have been forwarded by the executive engineer PWD from a Biswanath District Territorial Road Division to the office of the, it was forwarded to whom?
To the civil engineer.
To the office of the chief engineer, PWD Assam, for clearance of the bill of the petitioner, pursuant whereto 50% of the amount has already been released. Full stop. However, since the direction of the court was to clear the bills of the petitioners by following the guideline in the case of Tamshir Ali and others versus State of Assam, reported in 2008, bracket close 4 GLT 1. The matter will be, the order of the court will be complied in accordance with the said guidelines. First up, Mr. Gogoi has further submitted that since neither the chief engineer nor the executive engineer or even the finance, even the concerned official of the finance department is a party in this contempt case, hence the same is not maintainable. First up, after going through the materials on record, it appears that the court had directed personal appearance of the respondent number 2 on account of the fact that the respondent's counsel did not appear before the court on the last day. Although this is an old pending contempt case instituted in the year 2015. Be that as it may, after hearing the submission of learned counsel for the parties, this court is of the opinion that in the absence of the necessary party responsible for implementation of the court order, this contempt case cannot survive. Moreover, since the direction is to comply with the court order by following the directives of by following the principles laid down in the case of Tamshir Ali, no further order can be passed in this contempt case unless it is specifically pleaded and demonstrated that the guidelines laid down in Tamshir Ali Supra has been violated. As such, by granting liberty to the petitioner to file appropriate repetition, if he continues to remain aggrieved in the matter, this contempt case stands closed. Personal appearance of Sri So-and-so is hereby disposed of.
May it please, Lordship. Lordship, though file has been taken back from me, Lordship, I think it become infectious in view that the petitioner has taken fairness from the government. But I cannot make this submission, Lordship. You can make the submission, Lordship. File has been taken back from me.
Lordship, the respondent is also has been retired.
No, here is. Here is, Lordship.
Here is okay.
Mr. S.K. Goswami is present and submits that his client has taken away the file and therefore he is no longer authorized to appear in this case. Full stop. Mr.
You Ghosh, on
You
behalf
Ghosh.
of DP Board,
Learned Counsel has appeared on behalf of respondent number,
sole respondent.
on behalf of the sole respondent and submits that the petitioner has availed VRS and therefore the contempt case has become infectious. Full stop. Having regard to the direction issued by the order dated 27/3/2019, passed by the learned single judge in WPC number 1809/2019, directing the authorities
No, sir. No.
to allow the petitioner to serve in the regional dental college and restore all amenities as applicable to an employee of the RDC. In view of the submission made at the bar that the petitioner has already gone for voluntary retirement, bracket VRS. This contempt case has become infectious. As such, the contempt case stands closed.
Public.
Lordship made please my lord. This is a contempt application, my lord, violation of the order dated, my lord. 27/10/2021.
When is
Last
the
week,
order?
a large chance is given to them to obtain instruction. Well, what happened in this case, your lordship? Order of retention and regularization came in my favor, but benefit was given to another person, my lord. The same name, only the Chandra party's name, not there. My name is Bhuvan Chandra Das. And other details are same, except in the order of retention that
lord.
Chandra was not there. Benefit was given to that fellow. As of now, my lord, I filed a writ petition.
Don't say that fellow. That is not.
Lordship, I have not made him as a party respondent here because he's not.
No, use of expression such as this is
I'm
not
sorry,
proper.
I'm sorry, your lordship.
Hmm.
So, your lordship, this honorable court by the order dated 22/2/2019 passed an order, your lordship, at page 17 to 23 is the relevant portion, my lord.
Page 20, 19, 18. Relevant for 22.
Lordship,
Para 9.
para 4, my lord. Lordship, may I read?
My lord, against this order, we have preferred a review petition, my lord.
Lordship, then thereafter one more order of
Yes.
this honorable court is there.
For complying
Second.
with this order, a proposal was mooted, my lord. That, my lord, the finance department said, my lord, because of Umadevi and Upendas, we cannot now regularize someone. Of post, my lord, Umadevi. Now they've instructed us to prefer a review application against this order. We'd like to try that, my lord, we have already filed it. But, my lord, the bench is not available. My lord may see, my lord, page 18. Lordship is not there, my lord, here. Probably we will be, my lord, requesting the registry to at least make a possibility of having a video, my lord, by
Lordship,
Conferencing,
subsequent
right.
judgment of this honorable court, which I have filed, Lordship WPC 5643 at page 39, my lord.
No, what is the direction really?
my lord, direction is that, my lord, since, my lord, he has been left out and in his place, my lord, another person was regularized. So he should also be regularized and the other person should not be disturbed. Since he has also, my lord,
So other person was not entitled to.
he was not entitled because his name was not forwarded. Probably, my lord, he was not found to be eligible for regularization. Pursuant to the policy of 2005. prior to Umadevi.
No, the other person is also same name.
Name is same, madam.
Only Chandra is not there.
Chandra is.
Yes.
So, was the petitioner entitled to be regularized?
But according to the irrigation department, yes, he was the concerned person whose name was actually forwarded. But at the time when my lord issuing the
So it is a
regulation,
mistake, you have to rectify. It has nothing to do with Umadevi. Why are you complicating things unnecessary?
that's
You made a mistake in giving the wrong name. It is not on a principle of law. It can't be that if you have made a mistake, you made a mistake, forget it.
my
That
lord.
can't be the principle for the state. You made a mistake, rectify it. What is this point in review and this and that?
No, my lord, if proposals are now being, my lord, again mooted for regularization of the service of the present
Yeah, it will
petition.
be, it will have to be. A mistake, whenever you make a
It can be
mistake,
rectified, my lord,
Huh?
that's a different thing, my lord. But so far as my lord now regularizing, my lord, because in similar cases, my lord, we
no,
have-
it's not about now regularizing. Not about now regularizing. The regularization right does not evaporate. The right of this person will crystallize on that day when you made the mistake. Nothing subsequent to that will have any bearing.
Lordship.
So therefore, what option we have to proceed with the matter?
And here also, my lord, the concerned, my lord, commissioner and secretary who is, my lord, made a party. I'm
This is
appearing.
the only difference you have in.
My lord, he is in veterinary department as on date. And my lord, this contempt petition was, my lord, so far as the court's order is concerned, it was, my lord, communicated sometime in 2019, so far as the first order is concerned.
First order was communicated, then thereafter they have issued order.
The second is of
document can be
2021. He was there for a short period of 5 months.
What are they supposed to do?
I
That's
understand,
why
my lord.
people every 6 months. This has become a regular feature. 6 months,
At
8
least, my
months,
lord,
1 year.
since we have preferred a review, at least further 1 week's time may be given, my lord. At least let us try, my lord. If no stay is granted, then, my lord, of course, we will have no other choice. Something, well, because in the, my lord, earlier proceedings, some proceedings, my lord.
No, Mr. Gogoi, let us first understand one thing.
My lord.
What will be done, what cannot be done, that is another thing.
My lord.
That you do your part, we will do our part.
Right.
That's not a problem.
My lord.
But let us understand what is the legal principle on which we are standing.
My lord.
That has to be clear, correct? Now, this man who was not regularized and he was a master roll worker. Is it?
Yes, yes, sir.
At a particular time, you took a policy decision to regularize all people
Yes.
of a particular category, which included the contempt petitioner.
Continuous service
Right.
till 1/4/1993.
There was a conscious decision to regularize this
My lord.
service. When this decision was at the stage of implementation, by either a bona fide mistake or some manipulation, somebody else's name, which resembles the name of the petitioner, got in and he got out.
He
Right.
was left out.
So that was a mistake. Either a bona fide or a mala fide, but it was a mistake. For which this man has not got the benefit of the decision of the government. There was a decision in his favor. That decision got scuttled because somebody somewhere in the
Right.
stage of implementation had either committed a mistake or done it deliberately. Now you are saying, all right, we have made a mistake, we have made a mistake. But now Umadevi has come, so we can't help it. That is not a legally acceptable argument. His right is crystallized on that day when the mistake was made. So the determination will be in reference to that date. What is the review to be preferred here? You will prefer review, then if it is rejected, you will go to writ appeal. Why are you tormenting people of this category when it is a genuine case? If it is a case where you made a mistake,
My lord.
why are you tormenting them? You are making people like them run from pillar to post. What is the fault of these people? They are only asking for regularization, which they are entitled to, and the state has said that they are entitled to. What is the point in coming up with legalities and arguments? If it was that today he is asking for an order of regularization,
My lord.
in between the law has changed, it was a completely different matter. He did not get it because somebody made a mistake.
It was at the district level, man.
Yes. So
Otherwise,
is
the
it,
same was.
what is it taking? Is it a rocket science here that your officers are not understanding this? No, is it a, tell me one thing, Mr. Gogoi, you are also an officer of the, is there a rocket science involved in this? Why are you tormenting people like him, running from pillar to post, review petition, contempt case? what is the big deal about it? His right has crystallized on that day. The learned single judge
My lord.
might not have used the same expression as I am doing, but
No.
this is the tenor of the order. This is not the sign of a bright
Well, in
future
that-
of this country, which people are promising.
My lord.
If the genuine people are being made to run from pillar to post for these simple matters, I'm sorry to say, I can't accept that the administrative machinery is doing justice to the people. Is it not a clear injustice to this man? And you are saying you preferred a review petition X, Y, Z. Huh? Maybe you'll ask for a constitution bench. What is the big law point involved here? What is the mistake by the learned single judge here?
My lord, no, there's no such, my lord, one thing, my lord, one document, my lord, there was a interlocutory application preferred by the, my lord, state for, my lord, regularizing the left-out master workers post Uma Devi. This honorable division man said that, my lord, when the Supreme Court.
He is not post Uma Devi. He is the product of a mistake pre Uma Devi.
Lord, sir.
Let's be very clear about it.
My lord.
Don't even apply this analogy of post Uma Devi. Uma Devi laid down a law which law is always declared ab initio.
My lord.
If today this court declares a law, as long as it is there, it will apply from 1947. But only thing is you cannot take away right which is accrued to a person with retrospective effect. That applies to law legislated by the parliament and state as well as the judgment of the court, unless it is specifically provided. So Uma Devi will not take away a right already accrued in favor of someone. He had a right in his favor because of the policy decision of the government, which was to regularize. They wanted to regularize, but they made a mistake and regularized somebody else. You have to rectify the mistake. There's nothing to do here. Just rectify the mistake. And you catch hold of the person who has made the mistake and proceed against him. That's the law. And that's the only law.
My lord.
Mr. Gogoi, only because you make a request, I'm putting this matter on 30th
Yes.
of, not 30th,
At least 10 days,
On
maybe
the-
given, my lord, let me convey.
on the 16th of May.
My lord.
And there will be some order in this matter
June, 16th.
on that day, 16th of June.
My lord.
You can tell your officers
I will, my lord.
that they must see, these are people who are vulnerable.
Lord, sir.
Don't torment them. If he's a fake claim, he was not in service or he's just guilty of some misconduct, we will not support them. But it's a genuine case.
Lord, sir.
Why are you making him run from here to there, here to there? You prefer a review, then he will appear, then something will happen, then you'll go to. What is the big challenge here? There are matters where you can show your legal acumen, your prowess, fight it out.
My lord. Oblige me.
List again on so and so on the request of Mr. B. Gogoi, Leonard. The counsel for the respond number.
Respondent number 1 and 3.
So and so is present for petition.
1, 2, and 4.
So and so, WR department.
And
Your water resources,
Irrigation.
irrigation. What is your stand?
Lordship, my stand is Lordship, page 20.
You know, page, I'm not asking what is the page.
Lordship,
I'm asking what
in
is the
fact,
stand.
there is a mistake on the part of the. Lordship.
Rectify it.
That is,
You're
we have
making a
tried to
mistake and
rectify
then
it.
try
Lordship.
to, huh?
We have done, Lordship.
They have issued order retention. for a
Then why,
particular period.
what is the big problem with the finance department, Mr. Gogoi? This is totally unacceptable. You please communicate it to your officers. You make a mistake, the department admits it's a mistake, you don't want to correct it by hiding behind some judgment here and there. Yes, next matter, please.
I appear for respond number 3 only, my lord, not 1.
All right.
One issue, one
And-
revision. 2 and 4.
My please, your lordship. Please, a contempt matter, my lord. Order dated, my lord, 27/4/2022, my lord, is yet to be, my lord, complied with, my lord. Regarding
What is the order?
pensionary benefit.
Page number. Page number, please.
Page number, my lord, 15, my lord. And operating part is page, my lord, 18, para 8.
Order has been complied with.
We have sent it to the Director of Pension on 9th of March 23, along with family pension proposal, along with service book in original, everything we have sent, my lord, on 9th of March 23.
This is Commissioner of Panchayat.
Yes.
All right, now, who is the Commissioner of Panchayat a party
the-
here?
Yes, yes.
Direction was given to the principal secretary. He has sent the matter to the commissioner. He passed the order.
And
And-
Director of Pension is respond number?
8 minute, 5 and 8.
My learned friend is appearing probably.
Yes.
Earlier,
Oh.
step taken to the newly implemented
Yes,
matter.
Lordship, the present director was earlier, I am appearing for respondent number 5, Lordship. He has already retired from service, Lordship. But after the notice has been issued, Lordship, to the new present director, Lordship, he has not received a copy of this court's notice, Lordship. Just now I have.
Who is the present director?
Ranjan Bora, my lord. Mr. Ranjan Bora.
So I have sometime maybe you can also have take instruction, Lordship.
All right, you take down heard Mr.
M. Islam.
M. Islam, learned counsel for the petitioner. Also heard Mr. M. Nath, learned senior counsel assisted by Mr. A. Bhattacharjee, who has appeared for respond number
1 and 4, my lord.
1 and 4 and submit that instructions have already been issued by letter dated 9/3/2023, addressed to the Director of Pension, Assam, to process the pension claim of the petitioner. Full stop. Miss Miss M. Burman.
D.D. Burman.
D.D. Burman, sorry. D.D. Burman, direct counsel appearing for respond number 8 submits that the respond number not 8. Director, earlier director was who?
Respondent number 5,
5
Satyendra
minutes.
Kumar Sinha.
Appearing for respond number 5 and 8 submits that no copy of the communication has been received by the
Present
respond number 8, and therefore she be granted 2 weeks time to obtain instruction as to the steps taken on the basis of the communication dated 9/3/2023 issued by the respond number 4. Mr. S. Datta, learned counsel, is present on behalf of
Number 6, my lord.
on the respond number 6. In view of the prayer made by Ms. Burman, this matter is directed to be listed again on 14th of June 2023 as a fixed item, so as to enable her to obtain instruction. A copy of the communication dated 9/3/2023 be retained in the records.
I may be allowed to point out one thing, my lord.
Yes.
My lord, regarding the, my lord, letter dated 9 March 2023, and my lord, kindly see para 12 of this, my lord, page 20. Page 20, honorable court provided the length of service to be taken, total length of service. Here, my lord, they have taken only 17 years, 1 month and 30 days, my lord.
That we'll see. First, let them comply with you.
My lord. My lord, if requires, I may be allowed to take another fresh step, my lord, to the respondent number 8, my lord.
No, she has appeared. Respond number 8.
My lord, highly obliged, my lord.
It's a trace contempt, lordship. Order is at page 11, lordship.
Heard Mr. J. Abbas, learned counsel for the petitioner.
Direction is at page 13, last paragraph, lordship. Start from in view of the consent of the parties.
In full, et cetera, sole respondent, 8 weeks.
Obliged, my lord.
Item 51.
May I please, Lordship? Lordship, I'm praying for minor correction, Lordship.
Yes, what is the correction?
Lordship,
Instead of Kamrup rural, it should be Baksha.
instead of Baksha, it would be Kamrup Rural, Lordship. Page 8, Lordship, in the 5th line, Lordship.
Then why it was written Baksa? Let me see. Let me see the file.
DLC, Lordship, would be Kamrup, Lordship. Kamrup Rural, Lordship.
No, it is Baksa district. Then why Kamrup rural?
District Baksha is, Lordship, but the DLC, Lordship. DLC held in the
All right, take down. I heard Mr.
N. Hawk.
N. Hawk, learned counsel for the applicant. Also heard Ms. M.D. Bora, learned government advocate Assam appearing for the
1 and 3, my lord.
respondents 1 and 3. This IA has been filed with a prayer to correct typographical error occurring in order dated 10/5/2023, passed by this court in WPC number 951/2023. Mr. Hawk submits that although the district is Baksa, yet the DLC in this case was Kamrup Rural.
Lordship.
Therefore, however, it has been reflected in the order dated 10/5/2023 that the name of the DLC is Baksa. Full stop. Hence, the prayer for correction. Ms. Bora, Government Advocate Assam submits that there is no objection if the prayer is allowed. In view of the above, and after going through the statements made in the petition, I find that the prayer made by the applicant is justified and therefore deserves to be allowed. As such, it is hereby clarified that the expression DLC Baksa within quotes as appearing in the order dated 10/5/2023 shall be read as within quotes DLC Kamrup Rural unquote. With the above observation, I stand disposed of.
Supplementary list for order item 16.
Wait, please, Your Lordship. Lordship, we have challenged the impugn select list, my lord, dated 10/11/2022, my lord.
My lord may dispose of the matter. They have prepared an appeal, my lord. Gaon Buha Assembly.
That may be done, my lord.
All right,
Okay,
you take down.
Contempt.
Gaubura, selection or appointment?
Appointment, my lord.
Appointed already.
Yes,
Respond
ma'am.
number
Page 29.
Respond number 6 has already been
Yes,
appointed.
ma'am.
My lord. That's it.
Page
And,
35 is the relevant portion, my lord.
hmm,
15, serial number 15, my lord.
Take down heard Mr. S. Upadhyay and counsel for the petitioner. Also heard
I put 1 and 2.
Mr. S. Datta, Leonard SC Revenue appearing for respondent numbers 1 and 2.
Lordship, I am for 3, 4, and 5.
Ms. M.D. Bora, Leonard Government Advocate Assam for respondent numbers 3, 4, and 5.
My lord.
And Mr.
M.
M. Rahman appearing for respondent number 6. First up, by filing the writ petition, the selection and appointment of the respondent number 6 as the Gao Pradhan of village
Bosasimolu.
Bahasimolu,
Yes.
page 35 will get. Comma Majuli Char 1, 2, 3 under Moja Borsala in the district of Sonitpur has been put under challenge on the ground stated in the writ petition. First up, Mr. Upadhyay submits that the respondent number 6 has already been appointed. First up, Mr. S. Datta, Leonard SC Revenue submits that the order of appointment of the respondent number 7 is appealable under Rule 162 bracket C bracket close of the executive instructions framed under Assam Land and Revenue Regulation 1886, and therefore this writ petition be dismissed as not maintainable due to availability of alternative remedy. Similar is the submission of the other council similar is the submission of the council representing the other respondents. Full stop. Since it is not in dispute that the order of appointment of respondent number 6 as Gao Pradhan is appealable under Rule 162 bracket C. Hence, this writ petition is being disposed of by granting leave to the petitioner to prefer appeal under Rule 162 bracket C along with an application for condonation of delay, explaining the reason for delay. Full stop. If such an appeal is preferred within 2 weeks from today by enclosing a certified copy of this order.
Pardon me, my lord. My lord, appeal already has been filed, my lord. Before the commissioner, my lord.
Appeal already is.
Yes, my lord. That may be disposed of, my lord.
Appeal was filed before the.
Commissioner, yes, my lord. I have annexed it, my lord.
The order is appealable, etc. Then responding to the above,
Page 40, my lord.
Mr. Upadhyay submits that
No, this is the deputy commissioner.
appeal has already been filed before the divisional commissioner, but no order has been passed in respect thereof.
Maybe
till today.
is there representation? Representation is there. Page 40.
Page 40 is a representation, my lord.
Maybe.
Understood. It appears
Page 40 is representation.
from perusal of the record that a representation dated 21/11/2022 bracket annexure 8 was submitted by the petitioner before the divisional commissioner of what is it, Central Assam?
Not
Yeah, that's
Assam division.
Not
but
Assam division.
we have filed
Before
that.
the, most probably this is the deputy, before deputy commissioner, deputy commissioner, my lord.
He is not the appellate authority, deputy commissioner. The order has been passed by the DC. You have to file.
No, page 40 is not deputy commissioner, it is
Page-
commissioner.
40, my lord. Commissioner, yes, my lord. It's commissioners. Commissioner.
This is divisional commissioner, the jurisdictional divisional commissioner. A representation date was filed on 21/11/22 before the jurisdictional deputy commissioner assailing the appointment of the respondent number 6 as Gaon Pradhan of lot number 30.
Definitely disposal of the appellate, my lord.
Lot number 30. Is that this lot number 30? Pasai Malu.
Pasa Simolu, my lord.
Basa Simalu. Understood. In view of the above, this writ petition is disposed of with a direction that the representation dated 21/11/22 submitted by the petitioner shall be treated as an appeal under Rule 162 bracket C of the executive instructions, and the same be disposed of within the statutory period by a reasoned order. Construct. Facilitating the above, the petitioner to produce a certified copy of this order before the concerned authority.
I am highly obliged.
Writ petition
Keep the
stands
applicant.
disposed of.
In this case, we have somehow misplaced the brief, lordship. So I pray that it may be adjourned and we, in the meantime, we'll reconstruct the brief, lordship.
All right, Mr. MP Sharma, Lorry counsel for the petitioner submits that the brief has been misplaced in his chamber, in his office, and therefore some time be granted for reconstruction of the brief. Mr.
K Upamanya,
K. Upamanyu, Lorry counsel is present on behalf of
S Datta.
respondent number
Assam respondent, sole respondent.
on behalf of this.
No, there are-
Respondent, no, on behalf of the
All
respondent.
the rest.
In view of
Lordship,
prayer made by
Ram-
Mr. Sharma, this matter, hearing of this matter stands adjourned for 4 weeks, so as to enable him to reconstruct the record. This is a 2014 matter.
Yes, lordship.
List this case immediately on reopening of the summer holidays.
Lordship. Obliged, lordship.
Obliged.
That's all.